members of the New York City Bar Association, lawyers and law professors around the country, fellow citizens, and members of the public concerned about the rule of law in the United States. I'm Stephen Cass, chair of the New York Bar's Task Force on the Rule of Law. It is my pleasure to welcome you to this fourth session of the Rule of Law Forum. Our first session, keynoted by Tim Snyder, was a survey of current threats to the rule of law in our nation. The second session, with Donald Ayer as the keynote speaker, dealt with the undermining of checks and balances in our federal government. The third session, of the keynote speaker of which was Charles Freed, addressed threats to our judicial system and local law enforcement. All of these sessions have been recorded and are available for viewing on the New York Bar's website, www.abcny.org. Today's session, which is also being recorded, addresses threats to critical individual and societal rights that are essential to make our society not only lawful, but just. Our moderator today is Jennifer Rogers, a member of the Planning Committee for the Forum, a lecturer at Columbia Law School, a former assistant U.S. attorney for the Southern District of New York, and a well-known legal commentator on CNN. Many thanks to her and to all members of our Planning Committee, chaired by Bob Cusimano, and including Marcy Kahn and Josh Dratel, for conceiving and organizing this forum. It is now my pleasure to turn our virtual floor over to Jennifer Rogers, who will introduce our extraordinary array of speakers and explain how today's session will be conducted. Jennifer, the floor is yours.
Stephen. I'm thrilled to be moderating today's session. As Steve described, the first three sessions were phenomenal. And today in session 4, we're going to turn our focus to try to answer the question of whether the deteriorating rule of law, as we've discussed in the first 3 sessions, is leading to a degradation of individual rights in important areas like immigration and voting rights, criminal justice and policing, and freedom of speech. We have a fantastic group of 6 speakers for you today, which means we're going to have to be efficient in how we run today's program. What we will do is each speaker will talk for about 15 to 20 minutes, after which we will take some questions from all of you. Please, as we go along, drop your questions in the Q&A tab on the Zoom, and I'll go through them as the speakers are speaking, and we'll have some questions for each afterwards. At the end, if we have time, I hope we'll be able to bring everybody back on the screen for some further questions or from discussion amongst our panelists. I hope we get an opportunity to do that because this is a great group of people, and I want to hear from them as much as we possibly can. So we start today with a keynote speaker who is probably, frankly, the best person in the entire country to give us an overview of how the Trump administration is harming individual rights. Anthony Romero is the executive director of the American Civil Liberties Union. The ACLU, as you're all aware, vindicates violations of citizens' rights by filing actions against the government. They have done so at least hundreds of times during this administration. Maybe Anthony will tell us it's even more than that. But they've done that in all of the areas that we're going to talk about in further detail today, and many, many more. So without further ado, I give you Anthony Romero. Anthony, the floor is yours.
Thank you very much. Thank you, Professor Rogers, and thank you, members of the bar and colleagues. I'm delighted to be with you today. Earlier this month, the FBI arrested 13 conspirators in an alleged plot to kidnap 2 governors. This summer, we've seen peaceful marches in response to police violence in literally thousands of cities and violent altercations in dozens of them. In repeated public appearances, the President of the United States has refused to commit to accepting the results of the election should he lose. And 75% of Democrats and 64% of Republicans believe that members of the other party are not just wrong, but immoral. A lot of people will tell you that the system is broken, and there are a lot of reasons for people to think so. But I think that analysis is also incorrect. It's an erroneous mechanistic view of the system. It assumes that if all the inputs and all the mechanisms are functioning properly, we'll have a healthy democracy. Just as if you get the steel and the rubber and the paint to an automotive factory, all the workers show up on time, the assembly lines are running smoothly, that you might get the perfect car. And no one would claim that perfection in our democracy is possible. But there seems to be a feeling on both the left and the right that if we could, for example, get the right mix of Supreme Court justices, implement a fair and secure electoral system, perfects the tax code, and give every child a good education, we could get pretty close. But America isn't like that, and societies aren't like that. They're organic, they're not mechanistic. They are ecosystems where when they're functioning, everything comes together and balances in the long term, almost by themselves. Over the short term, there can be disruptions. But over time, a healthy ecosystem can heal itself. The Civil War, the Great Depression, the Red Scare, the upheavals of the 1960s, after each of these massive disruptions, the nation grew back, in some ways, healthier than it had been before. Yet today, we have a vindictive, take no prisoners partisanship that threatens the rights of Americans across the board. The problems we face are greater than the cumulative damage of the increasingly common assault on these rights. I would argue that right now we're experiencing a sort of societal climate change that threatens to disrupt the political environment so profoundly that it might take us decades before a healthy environment is able to reassert itself. The sea levels are rising and we have to build the structures that will hold it back, but we also have to address the root cause. So we're seeing these challenges in three broad arenas that I would like to discuss with you today. Three areas where I think what's really at stake are the heart and soul of our system of governance, of our system of checks and balances, of our democracy. First, we see attacks on the most vulnerable in our society. Second, we see attacks on democratic norms and institutions. And third, we see troubling changes in our judiciary as evidenced in the emergence of a shadow docket of the Supreme Court. My fellow panelists will demonstrate that these challenges are across the issue areas, whether it's criminal justice, immigration, voting, freedom of speech. But taken together, these dynamics represent not just a normal give and take of our democratic system, but more of a serious, some would say an existential threat to our democratic ecosystem. So let me address each one quickly. Attacks on the vulnerable. The Trump administration has largely thrived by turning people against one another and then attacking the vulnerable. Professor Rogers asked, how many cases has the ACLU filed against the Trump administration? By my count, it's 420 in the last 3+ years. The largest number of them is in the context of immigration. Immigrants became an obsessive focus early on for this administration, scapegoats for everything from crime to unemployment to the subversion of American values and culture. Administration policies range from the merely harsh to the criminally inhumane and clearly unconstitutional. The Attorney General of the United States was explicitly calling for the separation of families. We just read reports in the last 24 hours that 545 children remain separated from their families as a result of the official policy of separating kids from parents in deportation proceedings. And the Attorney General was clear, we need to take the children away, he said. It doesn't matter how young, added his deputy at another briefing. And we've won a number of victories against these policies, including the family separation lawsuit, which we continue to litigate to this day. More recently, the Ninth Circuit overturned a decision by Attorney General Barr that would have eliminated bond hearings for thousands of asylum seekers with credible fear of persecution in their home countries. And just this last week, the Supreme Court granted review in 3 ACLU cases against the Trump administration. All 3 of these Supreme Court cases are ones that challenge the administration's anti-Trump initiatives, anti-immigrant initiatives rather, although only one involves immigration law as such. The first, Trump versus New York, is our challenge to the president's announcement that he wants to or intends to subtract undocumented immigrants from the official census count on which apportionment of the House of Representatives is based. Under the Constitution, the statute, the president is required to count all residents of the United States, not just citizens or legal immigrants. But in July, he announced that he would exclude unlawful immigrants from the count, which would have the effect of reducing the number in the House for jurisdictions with significant immigrant populations. A 3-court judge declared the plan illegal, and the Supreme Court agreed to hear that case on an expedited basis. We will be in court on November 30th. The second Supreme Court case, Trump versus the Sierra Club, is our challenge to the border wall. You recall that Congress refused to appropriate funds for the wall that the president insisted to build, leading to a government shutdown. But when the president could not get his way with Congress, he redirected funds appropriated for other purposes to build that wall. We challenged the legality of those expenditures on a separation of powers theory and prevailed in the district court. And now the Supreme Court has also granted review this past week. The third case, Wolf versus Innovation Law Lab, challenges the return to Mexico policy, in which the administration has been sending back to Mexico asylum applicants at the southern border who have demonstrated a credible fear of persecution and who we believe are entitled to an immigration hearing of their asylum claims. Many are sent back to the highly dangerous areas of Mexico, regions which our own State Department warned us against traveling, and likened some of those areas to war zones in terms of danger. Again, here we successfully challenged the program in the district court and the Court of Appeals. And again, the Supreme Court just granted review. All in, we have 4 cases before the court this term. In each one of them, we are adverse to the Trump administration. The fourth, Fulton versus City of Philadelphia, asks whether Catholic Charities has a constitutional right to receive city funding to perform a government service while violating the terms of that service. Catholic Social Services seeks to certify families for the city's foster care program, but refuses to certify same-sex families, contrary to the city's non-discrimination provisions and laws. We represent 2 nonprofit organizations defending the city's policy, and that case will be argued on November 4th, the day after the election. In addition to these cases on immigrants' rights and LGBT rights, we've had to beat back laws that would have restricted abortions to the first weeks of pregnancy in Tennessee, Georgia, and Kentucky. Here, the parties who are adverse to us are not the federal government officials, but rather state governments. In July, though, we were able to block a Trump administration rule designed to make insurance companies stop offering coverage for abortions. It's this mix of both the federal and at the state level which has been most vexing to deal with the reproductive rights context. 9 states have attempted to use the pandemic as an excuse to ban abortion rights. We've had to bring emergency litigation in 7 of those states. And because of our work, none of those bans that we challenge are in effect. In these and dozens of other cases, the ACLU is defending the vulnerable from attacks by our very own government. We have become the de facto shield to the government's sword targeting the vulnerable. Second area of concern, targeting democratic norms. Here you see that the president has no fondness and no regard for democratic norms. A hallmark of the current era of politics has been a willingness to put partisan expedience ahead of constitutional rights that are the basis of our democracy. Not content with ballot security, legislation has been designed specifically to depress turnout by people of color and communities of color, as well as the young and the elderly. The president is leading an assault against mail-in voting, even as COVID surges and long lines are already commonplace at early polling locations across the country. Of course, most of those impacted by the long lines and the vulnerable to COVID are poor people in large cities, older voters, voters of color. We've won legal battles facilitating voting, mail-in voting for Virginia voters who didn't think that they could vote safely due to the pandemic. In Montana, we won a lawsuit that was endeavoring to prevent volunteers from helping isolated Native Americans cast a vote We were able to intervene and make sure that those efforts were ongoing. In Kentucky, we were able to force the dropping of requirements that would have put all voters at unnecessary risk of exposure in order to cast a ballot. We've had to file over 31 different voting rights lawsuits in more than 22 states over the last 6 months. And as a result of our litigation, the number of states permitting all eligible voters to cast their ballots by mail has expanded from 34 before the pandemic to 45 now. But the attack on democratic norms is also seen in the vindictive tribalism we see in our politics and how it manifests itself in the rhetoric on communities across this country. Peaceful Black Lives Matter protesters are labeled terrorists by the president. He touts his administration's gutting of housing regulations as a dog whistle threat to the suburban housewives of America, warning them that Biden will destroy your neighborhoods and your American dream. The president's rhetoric stands in stark contrast to the statements of his own FBI director, who tells Congress that the main threat to America comes from the far right, white supremacist militias. Attacks to our own democratic norms and institutions are found in challenges to First Amendment rights. The ACLU and the Knight First Amendment Institute jointly filed a brief opposing the Trump administration's efforts to block the publication of the former National Security Advisor, John Bolton's memoir. Before that, we joined with the Knight Institute to file a lawsuit on behalf of 5 public servants challenging the government's pre-publication review system, which prohibits former intelligence agency employees and military personnel from writing or speaking about topics related to their government service without pre-clearance, what we believe is a violation of their First and Fifth Amendment rights. The final area that has me concerned with the attack on individual rights has to do with the Supreme Court, and it's the increased frequency by which the Supreme Court has made major decisions in consequential cases without providing any reasons. It does this through what we call the Shadow Docket, a process by which it grants emergency stays of lower court decisions without full briefing, without argument or written opinion. Each year, the court hears about 9 to 10 of such cases and often takes consequential action while offering no explanation for its decisions. The legal scholar, Stephen Bladdick, has documented 36 applications by the Trump administration, with the court granting 19 in full, 4 in part, 8 denials, and 4 withdrawn. Those 36 cases on the Shadow Docket over the past 4 years compare to 8 across the 16 years of the Bush and Obama administrations combined. In the Bush and Obama years, the court only granted 4 of the 8, and none of them were controversial or provoked a dissent. The ACLU, we have seen this tactic, this use of the Shadow Docket, to eviscerate some of the victories we have won in lower courts. In Orange County, we were suing around the presence of COVID and the failure of an Orange County jail to follow safety measures recommended by the Center for Disease Control. The sheriff sought Supreme Court review of a case that we had succeeded in twice. And the Supreme Court has said that it would intervene in only the most extraordinary circumstances. Yet in a 5-4 decision, they reversed below and granted the stay. In the voting rights context, the court, in the midst of a pandemic, has used the same process to halt efforts to require states to maintain safe voting opportunities. 7 lower court decisions expanding access to the ballot in the presidential election were stopped dead in their tracks by this Shadow Docket of the Supreme Court. In the immigration context, the court recently allowed the Trump administration to end the census early, essentially ensuring that many of those people will not be counted after all. All of this done without ever issuing an opinion. When you consider the fact that the Supreme Court grants review each year in about 75 to 80 cases, the fact that its Shadow Docket is this robust should raise the eyebrows of jurists of all political persuasions. Law is essentially being made without the benefit of publicly released opinions or the normal give and take among litigants in front of the justices. The court presumably doesn't write opinions in these stays because it considers these applications on short notice, given their emergency nature. But the court has increasingly used them in non-emergency situations, like the Orange County jail case I referenced above. And when the lower courts consider the same type of emergency stay motions, they always write opinions explaining the rationale. Giving reasons is essential to the legitimacy of judicial decision-making. And if the lower courts can do it, why can't the Supreme Court? As I close, I want to go back to my climate change metaphor. I want to argue that our ability to address the challenges we confront has been fouled by a toxic political environment that needs to be cleaned up. We now doubt the efficacy of institutions. We don't believe in truth. We call into question norms and laws and values that have shaped the meaning of what America is. That we are a nation of immigrants, that a free and vocal press is good, that a house divided against itself cannot stand. As members of the bar, we must restate our commitment to a clean environment, that the legal system in which adversarial relationships can come together in search of true justice and not tribal dominance can help us restore a healthy balance and clean up the environment. I would argue that the fight to preserve and expand rights and liberties unites us more than divides us. There was once bipartisan support for civil rights and civil liberties, even immigrants' rights and reproductive rights. And we have to work hard to forge that consensus again, compromising on both the left and the right. We have to focus on those issues where we can reach across party lines and unite Democrats and Republicans, progressives and conservatives. Those issues and points of coincidence do exist and must be fully explored and developed. Here we can look to the Supreme Court for some encouragement. Some of the conservative justices have enabled the remarkable expansion and protection of rights and liberties. In Bostock versus Clayton County, Chief Justice Roberts and Justice Gorsuch joined with the liberals in extending employment rights to LGBT individuals. In June Medical Services versus Russo, the Supreme Court struck down an attempt by the state of Louisiana to do an end run to Roe versus Wade. And Louisiana had imposed regulations that would have forced every abortion provider in the state but one to close. And here, Justice Roberts joined the liberals in standing up for the principle of stare decisis. In the case affecting 700,000 dreamers who were born overseas and grew up as Americans, Chief Justice Roberts once again joined the majority, ruling that presidents and their appointees cannot circumvent established rules and procedures for fear of politics or incompetence. This is a beginning that can be built upon. Each of these issues has been the subject of intense partisan debate, but they are all issues in which a significant number of self-described conservatives find themselves in agreement with the so-called progressives on those issues. And if it can happen in the reified Supreme Court, it can happen elsewhere. The ACLU has worked with the Trump administration, for instance, also on criminal justice reform. I have spent a great deal of time with Jared Kushner in helping enact the First Step Act, which helped eliminate 3-strike sentencing for some offenses and expanded judges' discretion in sentencing of nonviolent crimes. Another place where we can coincide, progressives with conservatives, is on the doctrine of qualified immunity. And as you all know, as members of the bar, qualified immunity gives police protection from lawsuits unless the victims of constitutional violations can show that the police officer's actions were so egregious that no reasonable officer would believe them unlawful. This is a set of issues in which you actually have a coincidence of Chief Justice Roberts and Justice Thomas, with Justice Sotomayor. There are government officials who've been granted immunity for egregious violations, including school officials who ordered a strip search of a middle school girl in violation of our Fourth Amendment rights. And when you think about the fact that Clarence Thomas and Sonia Sotomayor, the ACLU and Cato, the NAACP Legal Defense Fund, and the Libertarian Institute for Justice have all come together. This provides a unique opportunity for us to coincide on reform. Rather than perpetuating an ongoing war between the Montagues and Capulets in our political Verona, efforts to preserve and expand rights can be the very grounds on which we can come together. Rights and liberties adjudicated fairly in the adversarial legal system can provide the means and the vehicle for uniting the country rather than fracturing us apart. You can call me naive or narcissistic as a fellow member of the bar, but I believe judges and lawyers play a critical role in forging a new path for the country. In many ways, our judicial system, even one that has a cutthroat Darwinian culture, can counterintuitively support a flourishing environment and can be the very place where this transformation begins. The system has for hundreds of years in America and elsewhere been a force for progress and a source of unity. 70 years ago, it would have been hard to imagine a more bitterly divisive issue than integrating public schools. Just as last week, we had a conservative nominee to the Supreme Court describing Brown versus Board of Education as super precedent that can never be overturned. The shift from zero-sum partisanship to a focus on rights that protect and benefit us all has the potential to heal current divisions and return us to a focus of first principles that defined our country. However imperfectly, and for many years, we can continue to double down on the promise that we are a nation committed to liberty and justice for all. Thank you.
Thank you, Anthony. So let's get to some questions. We have a number of questions from our audience members. One question is, isn't it that the taking of cases by the Supreme Court of cases that the ACLU won below, is that an ominous sign for you? Does that suggest that those are going to be overturned and you're going to lose ultimately at the high court?
Do you want to take multiple questions and then queue them up, or just one by one, do you think?
Well, actually, let me pair that with another one because it's kind of in the same vein. One of our audience members has asked, and I think this may be something that many of us haven't heard much about, the shadow docket.
Yeah.
We're all now very concerned about the shadow docket. These other things that you talked about, we already were concerned about. Now we've got the shadow docket to add to our list of nightmares. What can we do about the shadow docket, the issue that you've described as the shadow docket?
So first, the cases of the court takes and whether that represents good news or bad news. I mean, we spend a great deal of time at the organization making sure that when we bring cases up to the court, we are clear-eyed in our assessment about the potential of making bad law. And there are many cases that we either will not pursue or that we settle or that we take a loss and then decide not to further appeal. And yet, but if we only brought the cases we won, we wouldn't be bringing all the cases we need to. And every once in a while, there are cases that are, even our friends bet against us and we pull it through. I think the three I referenced, both the Bostock LGBT case, the census case, where we were able to secure the vote of Justice Roberts, and the Dreamers case, were cases that many, even allies of ours, thought that we would not succeed at the court. And I think part of what we do as good lawyers is that we think through the theories and the arguments. And since we are up in front of the court as often as we are, I don't think there's any other organization that has a larger docket than we. I mean, 4 cases where we are direct counsel, where our lawyers will argue those cases, is something that most of the big firms would die to have that record. Last term, it was 3. We really do think very strategically about them. And so we will see. I am most worried about the one, I don't like to bet ever against my team, but I think the one I'm most worried about is the LGBT case that's coming before the court, the Philadelphia, the Fuller County case, where this clash between religious freedom and LGBT rights has been posited once again. We didn't do well with Masterpiece Cake Shop, that was our case. Didn't have the broader implications that this one might. And again, with the possible confirmation of Judge Amy Coney Barrett on the Supreme Court. As someone who has very strong thoughts on religious freedom, I worry how she might rule in that instance. So those are the areas we're most concerned about, especially the clash between rights and the clash between religious freedom and LGBT rights. The shadow docket, this is why I thought I would pull this out. It's a trick out of my hat, because I knew that the bar, you have to come up with something new to be somewhat engaging for this bar association. I know this is a very erudite audience, and so I didn't want to just rehash what everyone already knows and can watch on television. The scholar to watch on this one is Stephen Bladdick. I mentioned him. You should all Google him. I think he's working on a book on this very topic. And it's the growth and the use of the shadow docket, the lack of its transparency, and the fact that they're making law without, full arguments and without explaining their judicial decisions, I think really is of great concern. There are a number of places where we've really scratched our heads and say, how is it possible that this is an outcome of the court, and we don't know why or how, and we can't fully engage or change the way they viewed it, and it's it's an area of substantial concern, especially in the voting rights context. It's been the place where we have been most concerned in the misuse of the shadow docket. I think we'll have to as jurists and as members of the bar, I think the court really holds its reputation in very high, it gives a high value to it. And so I think as members of the bar, both left and right, begin to raise questions of ruling in cases and yet not having proper oral arguments and not having the benefit of published opinions, especially as the lower courts do, because they see emergency stay motions all the time, and they're able to turn out motions to explain their thinking and explain their application of the law.
So Steve Bladdick, for those in the audience on Twitter, is an active tweeter. So you can follow him on Twitter, and he often talks about this and issues like this. Another question we got from an audience member is about the ACLU's views on freedom of speech as they apply to the president when saying things that might incite violence. So for example, the Proud Boys stand by, things that he says that actually might harm people.
Yeah, you have to look at
what does the ACLU think about that?
We're not a popular organization in the progressive community by some of our views on some of this one, on some of these issues. You have to go back to Brandenburg, which was our case in the court long before I got there. I've only been there 19 years. But Brandenburg and the importance of incitement and the imminence, the tests. Stand back, stand by. There's not the nexus you often look at in terms of the temporal imminence. And I think it's really important that we take as a viewpoint, and here we've sometimes disagreed with our sister groups who are endeavoring to either shut down the president's statements on Twitter or Facebook. We worry about Facebook becoming the Uber censor of speech. And while it is certainly a private company, it has every right to set its own terms of service and kick people on and off its platform, Twitter, Facebook, all these others. It's not the same thing as protests on a street or pamphleting in a town square. At the same time, it's become so ubiquitous, these social media platforms, that when you give the private sector and the leaders of these companies that power to decide what speech is allowed or not allowed on their terms of service, we worry. We are generally of the mind that the best speech, the speech you don't like, is more speech. Now, in the internet context, obviously, that's a little bit more challenging because some of the speech is not publicly announced. It's very targeted just, with the targeted advertising and the algorithms that have certain speech that's kind of laser focused on certain constituents. And so there we've argued for greater transparency. I think that kind of the transparency of how these political ads are when they're published, who they're targeting, what the reach of it is. And then, of course, obviously, if there are more neutral prohibitions on political ads, like the blackout dates that Facebook and Twitter have recently announced, that are applied across the board, are less problematic to us than the kind of the picking and choosing of speech and conduct, speech and content rather. It's probably the most, for us, especially political speech is the most protected speech you want to be the most concerned about before government begins to shut down. Obviously we have other people on the panel who give much, David and others will give a much more thoughtful and thorough response on this from their own background. But that's how we approach it.
Great. And quickly, in the last couple of minutes before we move on, is there anything that gives you optimism? We've talked a lot about your concerns. Looking ahead, what do you see, and what can we do as lawyers and as citizens to help you and groups like you to vindicate people's rights?
I think it's incredibly important that we as lawyers and that we as members of the bar not let rights and kind of the debate for rights become so politicized and so partisan. It's one of the things I lament in the, I've been, as I mentioned, I've been director of the ACLU for 19 years. There once were Republicans that I could sit and talk with who were pro-voting rights and pro-immigrants' rights and pro even reproductive rights. There were libertarians within the Republican Party who were very powerful and vocal. Those voices still exist, but they're not heard as loudly and as clearly. And I think for members of the bar, being able to kind of identify with those organizations that are doing this work, even if the ACLU feels too progressive to be, your preferred cup of tea, there's great work being done by Cato. There's really important work that they are thoughtful, right of center libertarians who will do the right thing on reproductive rights and LGBT rights. I mean, we have coincided with them on a number of places. And I think this is an important time where we not just relegate or delegate the concern for rights and liberties to a certain part of the ecosystem, the left end of the ecosystem. I think it's critically important that this be part of the official kind of mainstream, if you will, of the bar. I remember thinking really those were moments when you could actually make a difference. And I think it's important for those of us in my community, where I tell this to my folks, I spend a great deal of time, I did less so in the last couple of months, but I spent a great deal of time with Jared Kushner in the West Wing, not just on criminal justice reform, where it was easier to coincide. We spent a lot of time debating immigration and having kick-out brawls on the policies they were producing. And I think it's really important that we engage. And some of my colleagues at the ACLU, when I would say, we're going to a meeting at the West Wing, we're going to talk to Kushner and his colleagues around immigration, my folks would be, you would think I was taking them to the third circle of Dante's Inferno. And I'm like, this is our job. This is what we do. We engage the government leaders who want to talk to us about our issues. We're not going to change our point of view just by the reason that we go there and we come out. We're not going to be miraculously converted to the point of view of Stephen Miller. But we will engage, because that is what one does in this process. And I think if there's anything I do lament is the need for all sides, including my side, my good folks who work with me at my organization and other colleagues. We need to have the courage of our convictions and really try to reach across the party aisle, because this level of tribalism and this level of finger pointing and intolerance is not going to get us as far as we need to go.
That's terrific. Thank you so much, Anthony. You know, there's a lot of reason for concern, but I think some reason for optimism too in your words. And we thank you for what you do. And hopefully at the end, we'll have some more time to speak to you.
Great.
Thanks
Thank
again.
You. Thank you.
So we are turning now to Myrna Perez. Myrna is the director of the Brennan Center's Voting Rights and Elections program. She writes, speaks, teaches, and litigates in these areas extensively. She is, I'm told, the voting and elections expert. And I got to say, that seems pretty important right now, less than 2 weeks away from such a critically important election, as people are across the nation are voting even as we speak. So thank you so much, Myrna, for joining us, and take it away.
Buenas tardes, good afternoon. I'm Myrna Perez. I am the director of the Voting Rights and Elections program at the Brennan Center for Justice at NYU School of Law. For those of you who are unfamiliar with us, we are named after the great Justice William Brennan, who made famous the idea of a living constitution. Specifically the idea that the words of the Constitution were not static, but they needed to be able to expand and adapt to the challenges of the moment. And right now, our moment is experiencing quite a number of challenges. The talk that we have all been asked to give is related to individual and societal threats, or individual threats to individual and societal rights. And I have divided up my remarks into 2 buckets. The first are those threats that I work on during the day, and then those threats that keep me up at night. So the first are more nuts and bolts, the things that I would call block and tackle kind of problems. The second are more existential or metaphysical. So I'm going to try to get through a lot because election law is vast, and I know that it is on the top of people's minds. So the first bucket that I want to talk about is bad or discriminatory election day experiences. Obviously, elections are the way we resolve our political differences peacefully. They need to have legitimacy, and both people need to be able to trust their outcome, and they need to be reflective and representative of all of us in order to be able to do their job, which is to represent the will of the people in the way that the country is moving and in the kinds of politicians and leaders that we are electing. So one big concern that is on people's minds is what I am broadly calling intimidation at the polls. And that, depending on who you speak with, it could take a bunch of different variants. One of them is some sort of troops of some sort, National Guard, military going in, being directed by the president. Another variant on that is the use of paramilitary forces that come from other governmental services like Homeland Security and the like. Others are police officers being at the polls. Others are persons who self-appoint themselves as being policers of the polls, a la like the Proud Boys threat, a la the people in Erie, Pennsylvania that have said that they're going to be watching the polls and carrying their guns with them. And then the idea of challengers, which are people that have a semi-quasi-official role of actually lodging challenges on election day as to who might be eligible to vote. Another potentially threatening to individual rights and societal rights on election day has to do with long lines. We issued a report in the summer which indicated a number of pretty interesting findings. One, people of color tend to wait longer in line. 2, people of color are disproportionately represented in the longest of election lines. And 3, those communities that are undergoing the most rapid demographic shifts are getting fewer resources per voter as they become more poor and less white. I'm going to say that again. Those communities that are undergoing significant demographic shifts and are becoming more poor and less white will have, as a statistical matter, fewer resources per voter. And by resources, we're calling them polling places, poll workers, and machines. This is obviously a problem because if people have different election day experiences, people are going to be concerned about that. People are going to be worried about an accurate vote count. People are going to be worried about voter suppression. And in the past, long lines may have been deterring or disenfranchising, but in a time of a 1 in a century global pandemic that is transmitted by air, these lines could actually be deadly. Another discriminatory or bad election day experience that threatens individual or societal rights would be that of purges. What is a purge? Every state in the country does some effort to try and keep their voter rolls clean and accurate. That means removing people who have died, removing people who have been disenfranchised because of a criminal conviction, adjusting or updating people who have moved. The concern is when this list maintenance activity is too close to an election, sloppy, and done without notice. And so there are errors made and people don't find out about it until election day. At that point, it is almost always going to be too late. You do have some formal rights like being able to cast a provisional ballot and other sort of efforts that one may be able to appeal to. But the vast majority of Americans are not going to be able to cast a ballot that counts if they find out on election day that they have been purged. Another problem with respect to election day is simply election administrators poorly predicting what sort of supplies they need. You know, not having enough machines, not having backup for their poll books that are going to be moving slow, not having enough poll workers, not having enough poll workers who speak language, not having enough emergency ballots in case the machines go down, not having enough provisional ballots in case there was a purge and people are using them. So the second big bucket of threats has to do with false claims of fraud or voter fraud. As has been explored extensively by academics from all sorts of political backgrounds and political leanings, again and again, systematic, widespread fraud perpetrated by voters is very, very rare. There will certainly be some miscreants out there who try to exploit the system for their own gain. There's certainly fraud that has been perpetrated among voters by insiders who know how to exploit the system, but it is really, really rare as a statistical matter, approaching non-zero, for there to be approaching zero, for there to be widespread systematic fraud in the system. But yet the way we hear about it tells a different story. And these fraud lies that are out there really do have a pernicious effect on our electoral system in a number of ways. One, fraud has been used to try and discredit vote by mail, which again, in a time of a global pandemic, is an alternative to voters that needs to be taken advantage of, especially by folks who have health needs or high risk and who may have mobility or other issues and shouldn't be spending times on buses or getting to polling locations. It's highly racialized. Many of us won't forget the kinds of claims that we heard coming from the president after it was discovered what the popular vote looked like. And it was all about certain voters in California and in Texas with highly racialized language about who was committing the fraud. And when you have this kind of othering, when you have this kind of attack on certain segments of the community, it's no wonder that it's hard to get buy-in and get support for our institutions when there's a very, very clear statement being made by people at very high levels of government that not all of us are welcome. The other really interesting thing, I think, for this audience is that fraud has been used to justify other laws. So, for example, when people are passing laws like in Texas, or like in Florida, or like in Wisconsin, certainly right after the 2010, when we saw like a lot of restrictive legislation passed across the country, fraud and trying to combat fraud was a big justification for them, whether it ranged from cutting back early voting, trying to impose documentary proof of citizenship requirements, really restrictive photo identification laws that up to 8 to 12% of eligible Americans didn't have. We saw that being used. We saw fraud being used as an excuse for doing that. But something that is interesting that is happening now is that fraud is now being used to try and attack pro-voter reforms. So in a number of cases in the last few months, and I'm thinking of California, New Jersey, and Pennsylvania specifically, there has been a complaints lodged against election officials for doing things like making vote by mail more accessible or having drop boxes or both. And they were arguing a vote dilution theory. And for those of you that practice election law, the vote dilution theory has in its origins redistricting cases, which were largely used to try and make sure that communities of color have adequate representation in the redistricting process. This was a turning the doctrine on its head to argue that fraudulent activity that is going to happen because of these pro-voter reforms or this access to more access to vote by mail was going to dilute the voting strength of honest electors. They haven't gotten very far. Nothing has grabbed hold yet, but it is happening in enough places that this is something doctrinally that organizations like mine and organizations like Anthony are paying a lot of attention to. Another big thing to watch on election day, again, in the bucket, in the realm of things that I'm working on during the day, have to do with combating deceptive practices. What is a deceptive practice? It's misinformation or disinformation that is going to tell the public something that is not true about the voting process. What day the election is, what they are required to vote, what sort of rules are in place that may or may not be true. The difference between disinformation is that it's something that somebody's actively doing and doing on purpose, and misinformation is a mistake, something that somebody didn't intend to do but got something wrong or didn't fix something. This is a challenge because in order to combat the misinformation or disinformation, you need to saturate the airwaves with correct information. And when people don't know who to trust, that becomes harder. And then, as Anthony mentioned earlier, people are becoming more insulated. So they're listening to their closed networks a little bit more and not going outside of their circle to test the kind of information that they're getting. Moving on, I think other big threats that we need to worry about is the threats to the laws that we use to protect the right to vote. There was a major weakening of the storied Voting Rights Act in a case called Shelby County versus Holder, which this bar association spent a lot of time talking about in 2013 once it happened, which weakened what was known as Section 5 of the Voting Rights Act, also known as the preclearance part of the Voting Rights Act. That was a particular portion of the Voting Rights Act that took those jurisdictions that had egregious histories of racial discrimination in voting and said that before they could make any new election change, they needed to demonstrate that this change would not make voters worse off and was not done with the intent of making voters worse off. And once we have lost Section 5, that opened up the floodgates for a lot of challenging voting laws to happen that have made it extraordinarily burdensome and has spurred all sorts of other voting lawsuits under a different provision of the Voting Rights Act called Section 2 of the Voting Rights Act, which is nationwide in its coverage. So it's not limited to just areas with egregious history. It looks at policies and practices that impede voters' ability to elect their candidate of choice. And it has been primarily the tool that litigators like me and like Anthony's team do to try and protect voting rights in this new era without Section 5. There is a case that has been granted cert dealing with Section 2 of the Voting Rights Act, a case that comes out of Arizona, that folks who are anti the Voting Rights Act have made very, very clear that they want to use this as a vehicle to either strike down Section 2 or seriously limit it. And if that happens, and we don't have Section 5, we are really going to be with minimal options, with much fewer options for protecting and preserving the right to vote. So that is a big threat. And very soon you can expect me reaching out to many members of y'all, asking for help with filing amicus briefs and providing public support and public forum on the importance of this issue, because this is going to be a very, very big case. And then finally on this area, I wanted to talk about the DOJ. The DOJ has not been filing pro-voter lawsuits right now. So it's been left to organizations like the ACLU and like the Brennan Center to be filing a number of these cases. Certainly having a robust and active DOJ on the side of voters is important as a moralizing force, but it's also important to getting the work done because the country's big and vote suppressors are everywhere. So that is the stuff that I work on during the day. I do want to spend a little bit of time talking about what is it that's keeping me up at night. And these are the more metaphysical or existential questions. The first is that we are going to be experiencing some depressed turnout because of the doom spiral that all of us seem to be in about what could go wrong in elections. And I understand it. Lawyers by disposition tend to be worriers, right? Like we need to be able to see around corners. We're trained in law school on all these like issue spotting where we're supposed to be imagining what could go wrong. And I worry that that not prioritizing or not planning in a way that suggests the likelihood of how these things could happen and what the likelihood of being successful in is going to depress and discourage some people from participating in voting. Now, let's be very clear, people are turning out in droves during early voting. We should be really excited about that. But vote suppression never works for everybody. Just like if I got a state to pass automatic voter registration or had a state pass election day registration, we couldn't expect 100% participation. We can't expect that one suppressive act is going to shut everybody out, but it carves out different percentages of the population. And we know that some eligible non-voting members of the population don't vote because they're disgusted or disgruntled with the system. They don't like the politicians. They think that all of the parties are the same. And when you have this kind of rhetoric that suggests that your vote doesn't matter because it's going to be suppressed, or your vote doesn't matter because someone's going to rig the elections, or your vote doesn't matter because foreign cyber criminals are going to hack the system, like it's really hard, especially now, when times are so tough for Americans to persuade people to be spending the time to go out and vote, or at least some segments of the population for whom voting is more burdensome. And the big thing that I think that's problem with focusing on the doom and gloom is that it denies the incredible power that people have in all of this. We have made a tremendous amount of progress as a field. Anthony highlighted some of them, but I think we can be really, really proud of how far we have come since March. Most of the states now are going to allow people to vote by mail if they've got a serious concern about COVID. More than half the states are providing postage prepaid for people if they vote by mail. Approximately half the states are either giving people mail ballots or sending mail ballots to people or sending mail ballot applications to people. We've seen election administrators making great strides in hardening their systems against cyber attacks. We are seeing people from the private sector jump in to try and fill in the breach from where we aren't assigning enough government money to try and help our election administrators run an election. So we're really making a lot of progress, and I think we need to not deny the power of the people. And I think focusing too much on the way things can go wrong sometimes ignores that and will disincentivize some people. So I think we need to be careful about how we talk about it. My next big concern is that we are going to forget that we actually do have systems for dealing with some of this. It is against the law in every state for somebody to go to the polls and intimidate somebody. It is illegal in many, many, many circumstances for military and paramilitary forces to be going to the polls to monitor our elections. We have lots of laws that protect people against intimidation and threats of intimidation. So these things aren't happening in a vacuum. We have measures for dealing with this. And by scaring voters and not reminding people that they're part of a system that we can enforce, I think is not allowing folks to be able to make sober adjustments and assessments over what their risk profiles are when how they vote. Another thing that's keeping me up at night is that we are denigrating into a point where there are no limits to the political hardball. I'm not naive. I know that a lot of this is politics and a lot of people are going to take advantage of whatever rules in place or allow them to do that. But we don't seem to be having the kinds of norms. We are seeing people do things that are really dastardly. I know a lot of people are talking about fixes or changes or adjustments at the federal level, ranging from filibuster reform to Supreme Court reform, but some of this is happening at the state and local level. I mean, one particular example I want to talk about has to do with one of our lawsuits in Florida dealing with the voting rights of people with criminal convictions. Many of you may have heard that we achieved a great victory in November of 2018 because we were able to pass an amendment that ended permanent disenfranchisement. But that law, that amendment is being undermined by state legislation. And very recently, the Secretary of State said that Secretary of State's office said that they were going to be telling local election administrators who should be removed, even though it would be illegal to be removing them right now. We think it is just a threatening factor. And then the last thing I want to say is I also worry that we, especially people from the bar, are going to put an over-reliance on the courts instead of winning in the court of a public opinion. There are a lot of cases out there. The jurisprudence is going to be messy. The jurisprudence in voting rights and other rights are going to be messy. We are seeing new interpretations being offered of things like the election clause. We are seeing the Voting Rights Act facing possible reinterpretation by the Supreme Court. We need to be in a position where we are every day making the public case for why our democracy needs to be robust and participatory and inclusive. We need to be explaining to people at all ages why our democracy works best when all of us are participating and including. And we need to not let our lawsuits and lawyers suck out the oxygen for all possible reform or momentum or excitement about what our country can do and what direction we can go in when we are hearing from all of us. Our country's in a real challenge right now, and we are not going to get ourselves out of it unless we leverage the experience and expertise of us all. And that means that we need to figure out a way that everybody's participating and everybody's voting.
Terrific. Thank you so much, Myrna. You know, a lot of questions came in and I had questions for you and you basically answered all of them as you were talking, or most of them. We taken a question specifically about what's going on in California with these fake official ballot boxes that have been placed around. What is the deal with that? I mean, that seems like such an obviously wrong thing to do. Is that clearly against the law? What can the authorities there do about it? And is this just one example of a more widespread problem that we can expect?
Well, the California case is interesting because after much discussion and negotiation and pushback, it now appears that these unofficial ballot boxes, even though some of them were labeled official, are going to look very differently than what they were originally put out at. They're not going to be done in the way that they were going to be done, if at all. One of the things that I find very ironic and very interesting is that California does permit individuals and groups to provide assistance to voters who need help getting their ballots and turning them in. And that has been something that a number of folks containing certain political leanings have been very opposed to. People think that that is fraudulent. People have been trying to change those laws. That was actually the subject of what some of the claims that the president was issuing about the fraud that was happening in California. But it's those laws that allow that kind of modified activity. So I think people are going to have to accept some consistency, like they're either going to account for the fact that some voters need assistance and that there are benefits that happen when a third party is able to collect and return those ballots or not. And I think this is a really good example of pointing out that there's voters are voters and they have needs, and it doesn't matter what their political background is. Like if they need ballot assistance, they need ballot assistance.
Great, thank you so much. We hope we have time at the end to get you back. There were some general questions around disinformation and whether more information is going to help us combat the disinformation. But I wanted,
absolutely happy to get to it.
yeah, I want to take that when we have all of us back to talk about it across all of these areas. So thank you so much, Myrna. So up next, we have Nicole Austin Hillary. Nicole is the Executive Director of the U.S. Program of Human Rights Watch. She works on combating systemic racism, including in the criminal justice system, among other areas. Nicole is a litigator, a scholar, and speaks to issues of equity and fairness all over the world. So Nicole, talk to us. The floor is yours.
Thank you. And I want to thank everyone for joining us today. I particularly want to say thank you because I think it speaks a lot to the thinking and the thoughtfulness of the bar that you included me and issues of rights in this discussion. Because when we talk about the threats to the rule of law, oftentimes people don't connect that to the issue of human rights. And one of the things that I've been preaching since I came to Human Rights Watch is that the issues of civil rights, human rights, and social justice are inextricably linked. And if we don't understand that connection and don't start talking about these issues in tandem, then we're missing the mark. So thank you all for being prescient and for understanding that connection and making sure that as we talk about not only the threats to the rule of law, but threats to rights, that it's important to have all of these issues discussed in a forum like this. I want to focus on 5 key areas that I think are important as we talk about the threat to the rule of law and the threat to rights. First of all, I want to talk about what I'm calling what used to be the elephant in the room, but now is no longer the elephant in the room, but what is front and center for all of us, not just in the United States, but globally. And that is systemic racism, inequality, COVID-19 and the disparities that result from it, and issues around policing. Second, I want to talk about violations of freedom of assembly, which are very much related to that first topic. Third, I want to talk about the issue of violations of migrants' rights. Then the threats to the right to vote. Although you heard my former colleague, Myrna Perez, speak so eloquently about that, I think it's important that people understand that the right to vote is one that is guaranteed and protected under international human rights law. So I want to make sure to bring that into our conversation a bit as well. And then finally, I want to talk about the overall retreat from international norms and accountability by the United States and what we need to be doing to try to protect that. And with each of these, I want to give just a few recommendations because I think it's important for us not just to talk about and identify what the problems and issues are, but I think it's always important in forums like this for us to be able to walk away with marching orders. You just heard Myrna say that we all have to be a part of the solution and we all have a role to play. Well, that's with respect to all of these issues. And so I want to make sure that I'm helping to arm us with the materials and information that we need to do just that. So first of all, talking about the issue of systemic racism, COVID, and policing. Look, we have seen an implosion in the United States. I don't need to reiterate any of that. We all have been living it. We all have been seeing it. But what's so important at this moment is understanding that the issue of systemic racism is an issue and a threat to the rule of law, not just to us in the United States, but around the world. The United States, in fact, has an opportunity right now to be leading the rest of the world in terms of how we respond to, react to, and how we move beyond the effects of systemic racism. And I hate to say that at this moment, we're not doing such a great job in leading the way, but we have an opportunity to do that. You know, we have seen that as a result of the various killings, and I'm not going to go down the list because it's a long list, we have seen people around the world recognize that issues of race and justice are indeed global issues, and they are indeed civil rights and human rights issues. And that we are at a moment such that recognizing the history of these abuses and tying them to the effects that we now see manifested currently is how we're going to move beyond them. And COVID and the pandemic that we're dealing with is a perfect example. Racial disparities in the enjoyment of the right to health in the United States are very stark right now, and they've been simply accentuated by COVID-19. We've seen communities of color, particularly Black and Latinx communities, devastated as a result of COVID. And we've seen that devastation, not just because of the underlying health issues that we've heard so many in the media talk about. Yes, there are underlying health issues, but those underlying health issues are related to the effects of systemic racism in this country. They're related to the fact that in Black and Brown communities, they have far fewer opportunities and options when it comes to good healthcare, when it comes to access to medical information, when it comes to access to good and quality food, when it comes to access to education, and all of those systems that need to work together in order to sustain healthy communities. You know, I was on an event earlier this morning, another virtual event, where I spoke to the head of an African-American women's rural group that works on voting and health issues. And she said, and it's in Alabama. And she said to me that in this particular area of Alabama where they are located, they have about 15,000 residents, most of whom are Black and Latinx. And in that community, they have one doctor and one hospital. And it's not even really a hospital, they call it a clinic, to represent and take care of 15,000 people. These are the issues that are stark and that threaten the rule of law in the United States. If we can't keep vast portions of our community healthy, if we can't give them the access that they need to equitable care and services, that is a threat to the rule of law. That is a threat to our democracy. Public health measures designed to slow the spread of the virus, like quarantines and stay-at-home orders, they have all disproportionately impacted people of color and those already living in our most vulnerable communities. We have low-wage earners who are in those communities who've lost their jobs at a much higher rate than middle or high-income earners. And for these individuals, the healthcare that they may have had access to has simply been reduced. We learned that in September, more than half of all US households, especially those with lower incomes, reported difficulties paying for their essential services and expenses, which included their health care. Workers deemed essential faced unsafe working conditions, leading to outbreaks, particularly in the agricultural and food production regions of our country. These are all threats to the rule of law. And what do we need to do to address those? Well, first of all, the United States needs to make certain that it's fulfilling the right to the highest attainable standard of health for everyone across the country, but especially during COVID-19. This includes ensuring testing, ensuring treatment and access without discrimination, and ensuring affordability for all people. In terms of our focus on COVID-19, economic and social relief efforts on the rights of the most vulnerable have to include extending benefits to them. We are all right now watching the fight that's going on in Washington, in Congress, regarding additional relief. These kinds of fights have to stop, and they have to be bipartisan efforts, which I know we all encourage, but that's the only way we're going to see real reform and real relief for these most vulnerable people. We have to ensure that these relief efforts guarantee them not only access to the monies that they need to take care of their families, but also gives them access to the health care and support that they need for their families to keep them alive and to ensure that the disparities that we have seen waging a war in those communities does not continue to manifest. And lastly, with respect to this particular section on systemic racism and abuse, I can't leave it without talking about the issue of policing. It is a threat to our rule of law if the United States cannot come to grips with how we are dealing with policing. I know earlier in Anthony's keynote, he talked about some of these issues. And I noticed that there was a question in the chat from someone, which I don't think we got to, but hopefully we will, about the whole issue of defunding the police. Look, for us in Human Rights Watch, the issue is not about defunding the police. And the issue around how we respond to this particular threat to the rule of law is not about defunding the police. It is about reinvesting resources so that we're meeting the needs of the community as the community is telling us they need them met. You know, at Human Rights Watch, that's what we do. We don't litigate. We have researchers that go on the ground, and we're embedded in communities, and we are talking directly to the most impacted people. Whether we're here in the United States in Tulsa, Oklahoma, where we worked closely with members of the African-American community there about policing issues stemming from the killing of Terrence Crutcher, or whether we're in a war-torn country in another part of the world. The heart of what we do is researching and identifying the harms that are coming to people and then determining what their needs are. We have to do that in the United States when we are talking about policing and how that is a threat to rule of law and to rights. People in communities are telling us this, and we document this in a report that we did back in September, where we talk about and list 14 principles for dealing with and reforming policing in the United States. And the key thing that we highlight is this: we have to take resources and spend them in ways that communities are saying are going to make them whole and are going to help them live the kind of vital and equitable and sustainable lives that they want. The things that people are telling us in the communities where we go are that rather than having their city council members put funding into bringing more ammunition to their police forces, what they want is more money for transportation, so that the poor and working class can get to the jobs that are now on the other side of town that they need to get to in order to make money, in order to feed their children, house them, and clothe them. Those are the kinds of basic things we need to be talking about when we have these conversations around disparities and around systemic racism and about policing. It's how do we make changes so that these systems are created in a way to give the community what they are telling us they need, not what we're telling them they need, but what they are telling us they need. So doing so is going to make a huge difference in terms of protecting people's rights and in terms of addressing this particular threat to the rule of law. Related to that is the issue of violations regarding freedom of assembly. You know, we all saw in March, after the killing of George Floyd, that there was an implosion, that people all across the United States took to the streets peacefully in an effort to say, we don't like what's happening in this country. We don't like how we are addressing issues around race. We don't like the treatment of people in disenfranchised and disadvantaged communities by the police, and we want to see change. But how we as a nation respond to those individuals who are taking to the streets and who are protesting relates to threats to the rule of law. Look, we all saw what happened in Washington on that fateful day when protesters were peacefully engaging at Lafayette Park, and the curfew had not yet gone into effect in Washington, and yet officers whom they entrust to protect and uphold the rule of law released tear gas and released other physical force to move those protesters and the individuals who they thought were in violation of the law. How we respond and deal with protests and our freedom of assembly, and if we don't do that in the right way, that is a threat to our rule of law. We know that tens of millions of people in all 50 states came out against police violence. One of the things that we know from being on the ground and talking to protesters is that protesters were saying they wanted to see accountability. They wanted to see accountability for police misconduct. They want to see a reduction in the scope and power of police and genuine reforms to the criminal legal system in the United States. The police in many instances, however, we saw responded to these protests, not just at Lafayette Park, but in other parts of the country with excessive force and abuse that we at Human Rights Watch were able to document. In fact, we just released a report 2 weeks ago about abuses that we were able to see and document in the Mott Haven neighborhood in the Bronx in New York, that gave firsthand accounts of people's experiences when they were trying to peacefully protest, but were met by resistance from the local police force in New York City. Many of those arrested around the country in that protest in Mott Haven and in other parts of the country were held for hours, sometimes for more than a day. They were held in crowded conditions. Many told us they were held in filthy conditions with no protection from COVID. Scores of journalists were among those attacked and arrested or otherwise harassed during the protest. Sometimes we saw that live on camera. I saw it, many of you saw it. The federal government deployed multiple federal agencies in many of those instances, some of whom had an apparent lack of training and crowd control and in terms of how you deal with protests. And these included myriad police agencies, including Customs and Border Protection, for whom we know at Human Rights Watch have a documented records of abuses when dealing with protesters. We as a country have to find a better way to deal with protecting the right to the freedom of assembly. We have an election coming up. We know we have people with varying opinions and who come out on different sides of the aisle with respect to issues and candidates. It is incumbent upon us to protect the rule of law, to ensure that the law enforcement agencies that we depend on to give voice and opportunity to peaceful protesters are trained and are doing their job in the way that we expect them to do so. So some of the recommendations that we think should be put in place include, first of all, ensuring that any agents or officers deployed to protest have adequate training and crowd control consistent with both domestic standards and international standards on policing and use of force. And we also want to see that they take measures to end serious police misconduct and human rights violations that have been documented in protests and that have been documented, again, in the long list of killings and abuses that we are all so familiar with, and in fact, too familiar with in recent history in this country. Those are things that we think must happen in order to address that threat to the rule of law and that threat to rights. We also need to talk about violations of migrants' rights. You know, we all saw in the news just this morning that 546 parents who had been previously separated from their children reported that they still have not been reconnected to their children. This is a problem. If we are to be a nation that provides opportunity and fairness for people who are seeking a better way of life and better opportunities, we have to make sure that the systems we have in place for evaluating those requests and those needs for asylum are done so in a way that is respectful of rights and respectful of our rule of law. What we saw at Human Rights Watch is as the COVID-19 pandemic accelerated in March, the US government, including the Centers for Disease Control and Prevention, speciously used public health to justify an order that resulted in summary expulsions of asylum seekers and the abrogation of long-standing protections for unaccompanied migrant children. Under that order, the US border agents are no longer required to ask migrants if they have a fear of returning to their home countries, something that had been standard here in the United States, even when these migrants express a strong fear of return and express that there is danger awaiting them should they be returned to their home countries. With border agents empowered unilaterally and summarily to decide these, what we call fear claims, the United States expelled more than 159,000 people along the US-Mexico border, including nearly 9,000 unaccompanied children through September 2020. And I have to tell you, I've spent time at the border talking to some of those migrant children who have been separated from their parents. I was able to witness the tears in their eyes. I was able to look at their shabbily clad bodies, and I was able to hear the fear in their voices. As a nation that upholds democracy, a threat to our rule of law is indeed one in which we do not make better and more equitable determinations about how we deal with these migrant communities as they seek asylum. So one of our biggest recommendations in the human rights community is that we repeal border measures that block asylum seekers and allow people who claim international protection access to a fair and efficient procedure that prioritizes the use of detention alternatives. This, again, must be done to undergird how we offer and protect the interests of people who are in the most vulnerable situations, and how we ensure that our rule of law is adhered to and respected. The last thing that I want to talk about is an overall retreat from international norms and accountability. The United States continues to disengage from multilateral institutions. Just in July, the United States informed the United Nations that it would withdraw from the World Health Organization. The US Department of State's Commission on Unalienable Rights, a body that was established in 2019 to re-examine US commitments to international human rights, released a report. And in that report, which came out in August, they advocated a hierarchical approach to human rights and relegating other rights that would ensure protections for vulnerable people. In September, the United States imposed sanctions against the International Criminal Court, the ICC. Prosecutor and another senior official put into effect a sweeping June executive order that authorized unprecedented asset freezes against ICC officials and others who assist certain ICC investigations. We have to ensure that we as a country recommit to multilateral institutions and international justice. We also have to ensure that we take a close look at sanctions that are aimed at undermining the ICC's essential mandate as a court of last resort. Again, these kinds of protections will ensure that we are respecting and upholding human rights, and that we are protecting the rule of law as we know it in the United States. And lastly, and very quickly, I just want to pick up where Myrna Perez left off, and that is discussing very quickly the threat to the right to vote. The right to vote is a right that is guaranteed in human rights law. And we as a nation should be looking to those laws and those treaties as an additional way to embolden and protect the voices and the rights of voters in the United States, regardless of their political persuasions, regardless of their thinking and their positions. That right is sacred and has to be guaranteed. And there is an opportunity while the rest of the world is looking at us, because they are looking at us very closely as the world's ostensibly greatest democracy, to see how we handle these issues and how we address issues around voter suppression and protecting the right to vote. It is important and necessary that we engage not just from a domestic point of view, but from a global point of view, to do all that we can to protect the right of vote, to ensure that voters' voices aren't suppressed, and to ensure that the systems around voting that you just heard Myrna say we can trust and that work, do indeed work as they should to provide equity and opportunity for all voters. So Jennifer, I will stop there and just say this very last thing, which is where I started. Issues around human rights, civil rights, and social justice are inextricably linked. We can do more to protect our rule of law and more to protect the rights of all people in this country if we understand and amass the various resources, the large amount of resources that we have, not only here in the United States, but through global partnerships to embolden our positions and to really ensure that we are protecting the rule of law. That is what is going to help get us beyond this very critical and challenging period that we're in, and really help to move us to being an even stronger democracy.
Thank you so much, Nicole. Wow, you really hit a lot of topics there. Let me ask you about a couple of things. We did get some questions in on the Q&A. And one is this tension between local policing and the feds coming in to control some of that. So, you know, in this administration, we've had them pull away from consent decrees and other means of trying to ensure that local police departments comply with civil rights law, et cetera. You know, where is that line drawn for you? Do you want more oversight of local police departments by the federal government, or in an administration like this, where they actually, as you mentioned, have sent federal troops in without identification, without training, to cause more problems than were there to begin with local authorities, is that actually not helpful at all? So kind of where do you draw that line? And then let me give you another one to kind of group them together a little bit. Sentencing. We didn't talk about sentencing in the criminal justice system and its disparate impact. This year, we had a lot of releases based on COVID-related issues. Were those a good thing? Were they applied fairly across populations? Can you talk a little bit about the notion of fairness and equity in sentencing?
Sure. And thank you for those great questions, Jennifer. And I will tell you, with respect to policing and support from the federal government, what we actually have done in our research, and I mentioned this a bit in my talk when I referenced Tulsa, we've actually been working directly with local police agencies, and we think that's really where it has to start. Local police agencies, as we all know, they're governed by their local leaders. City councils make decisions about their funding, about how funding is allocated, how much goes to them. That's really where the work has to start. They have an opportunity by looking at best practices, by looking at ways to work more closely with the community, listening to the community, working with community groups. They have opportunities to create the kind of change and to create the kind of police forces that their local communities are saying they need and want and that work for them. So I think that's where the work has to start. And so that means, and we know, we have hundreds of police forces across the country, but that's really where it has to begin. It frankly would be unwieldy and very difficult if the federal government tried to institute change within each of those local police forces. Now, that's not to say there's not a role for the federal government, because there absolutely is. And I've spent years working on advocacy issues, imploring the federal government to get involved and to really provide a framework for what local jurisdictions can do. But I think the work has to start locally. And again, some of the work that we've been doing in Tulsa, where we've worked directly with the chief of police there, we've been working directly with the city council and with the mayor there. That is where we are seeing the most cogent results and best outcomes resulting in terms of changing those communities. There's still a lot of work to be done in Tulsa. Let me just offer that asterisk, or that caveat rather, but I think that's where it has to start. In terms of sentencing and COVID and the releases, look, we at Human Rights Watch, we advocated and worked with coalitional partners across the country to ask for local jails and prisons across the country to make thoughtful decisions about releases to ensure that not only the inmates, but also their workers, those essential workers who have to be there every day and who then go home to their families and communities, to make sure that they are all safe by ensuring that the same issues that have always been a problem in our jails across the country around overcrowding, around cleanliness, around providing the right kind of health care and support that inmates need, all of those things, as we know, had a microscope, were put under a microscope as a result of COVID. So yes, overall, I think it was a good thing that we had some of these releases, with the understanding that they had to be done by first looking at sentences, looking at who was serving what amount of time, because we know, and this is probably a conversation for another forum, Jennifer, we know, as the questioner cited, there are disparities in terms of sentencing. And for many of the people who were released, particularly for us and some of the work we were doing in California, we know that some of those people were people who were serving draconian sentences that really did not fit the crime committed by those individuals. Those are the people whom we thought should have been given an opportunity to be released under early requirements based on COVID, as well as for the people who were older, who had shown themselves to be model inmates, and who showed themselves to be people who, once returned to the community, would actually be an asset to their community and help to deal with the myriad issues we are facing around COVID.
Great. And we're basically out of time, but if you can give me a close to a yes or no answer on this last one, I want to get this viewer's question in. The child separations that we've been hearing about for a long time now, but reading about in the last 24 to 48 hours, are those not violations of international law and also supportive of civil lawsuits? I mean, do these people have a good civil case that could be brought in the US? And is that conduct by our government a violation of human rights standards internationally?
Yes to the first half of your question, in that they are in violation of human rights laws. I'm going to give you a yes and no to the second part of that question because it's complicated. And hopefully maybe we can get into that a little bit more in terms of what options are available from a litigation standpoint.
Great. Thank you so much, Nicole. That was fascinating and so important for us to hear about. We really appreciate your time and your views, and we hope we'll see you at the end with more time. I'm really hoping.
Absolutely. You're welcome, Jennifer.
So next up, we have David Mcgraw. David is the top lawyer at the New York Times, and in that capacity, he has advised the paper on many of its huge stories, including WikiLeaks and the Edward Snowden disclosures, the more recent bombshell story about Donald Trump's tax returns, and much, much more. He also leads the Times's FOIA litigations in trying to get information out of the government so that they can report on it. His book is called Truth in Our Times, Inside the Fight for Press Freedom in the Age of Alternative Facts, and it was published just last year. So if you want to, after hearing David today, if you want to read more about him, his thoughts about this administration and what it's doing to truth and the role of the media, please pick that up. So David, let's hear from you. The floor is yours.
Thanks so much, Jennifer, and really appreciate the opportunity to speak on a panel that has such incredible lawyers. I'm going to take the conversation a little different direction because I'm going to talk about the freedom of the press, more of an institutional, societal type value as opposed to the individual rights we've heard so much about so eloquently. I always think back to what Donald Trump said in February 2016 when he was quoted as saying, "I'm going to open up our libel laws so when they write purposely negative and horrible and false articles, we can sue them and win lots of money. We're going to open up those libel laws so that when the New York Times writes a hit piece, which is a total disgrace, or when the Washington Post, which is there for other reasons, writes a hit piece, we can sue them and win money instead of having no chance of winning because they're totally protected." As a libel lawyer, I was curious about this because the first thing I thought was, well, how exactly does a president change the libel laws? The libel laws are a creature of state law, as everyone knows here, and of constitutional law decided by the courts, not so big a role for the president. But more than that, it was curious that Trump was coming out to change the libel law because if you follow the legal news of late, Trump is almost always on the wrong side of the V, right? Jacobus versus Trump, a libel suit. Carroll versus Trump, a libel suit. Zervas versus Trump, a libel suit, where he's the defendant. You would think that Mr. Trump would be lining up on my side of the ball and trying to protect the right of free expression, not wanting to change the laws. But more than anything, what was striking about his description of this, that he wanted the libel laws to allow plaintiffs to win when there are purposeful falsehoods, actually describes the current state of the law. If one of my students in one of my law classes had given that answer, I would have given them a very low grade for eloquence and for precision, but they had essentially captured Times versus Sullivan. When you write falsely and know it, you lose. That's how libel law works. But what's important from this statement is the implication of it, which is that the law harms. It allows reputation destroying falsity. That's the impression he leaves with his listeners. Almost exactly a year later, he then hit on one of his other favorite themes. When he wrote in a tweet, February 2017, the fake news media, the failing New York Times, NBC News, ABC, CBS, CNN, is not my enemy. It is the enemy of the American people. In one sense, that opening riff of his on libel sounds like he's talking about the rule of law, but it's a little bit like the attacks on, quote, fake news. It sounds like something someone would say if a person cared about the truth, but is really just the opposite. He's inviting people to label and dismiss rather than read and discern. And it's the same deal with his broadside against libel law. Sounds like rule of law when it is exactly the opposite. What you see is the conversion of two themes. The law, as misconstrued, protects those who harm America. It protects the enemies of the American people. The idea is to undermine the standing and authority of the independent press. The independent press in that vision do phony things thanks to unfair laws. Don't believe them and certainly don't protect them. So what you see are these two intertwined phenomena: the attack on important democratic institutions created and governed by our foundational legal precepts. And you can talk about the courts, you can talk about Congress, you can talk about voting, or you can talk about the press. Attacks on important democratic institutions and the disregard for law and our established legal processes. These institutions embody the rule of law and protect it. That's the synergy of them. The sad thing is, it's a message that's landed home. When I was finishing my book and was going to press, Ipsos, the polling company, surveyed people on their view of press freedom. 26% of the respondents said that the president should have the power to shut down news organizations that engage in bad behavior. 26%. 1 in 4 Americans wanted to give the president the power to shut down press organizations. Whatever you think about the press performance on any given day or in any given year or any given time, that is so far removed from what the founders thought of when they wrote the First Amendment. I say in my book, and this will be the last advertising for it, but I said it well, and so I just want to quote it. It doesn't really matter how much freedom the press has in a society if the press is not believed. A distrusted press is little different from a shackled press. It lacks the authority to mobilize public opinion against wrongdoing, corruption, and misguided policy. It has no voice to hold governments accountable. It gets ignored. I'm pretty sure that at some point, a disregard for the press translates into a disregard for the law of press freedom. There's no question, and I want to be clear about this, that the law of governing press freedom is a proper subject for reconsideration. This law strikes a very difficult balance. On one side, press freedom, on the other, reputation, privacy, freedom from emotional distress, national security. The outcome of all of those balances, or imbalances as it were, really determines what we know, how much transparency there is in government, whether we have a press that can serve as a monitor on government, whether we have a press that holds an administration accountable. But the great decisions of press freedom were made between 1964 and 1989 by the Supreme Court. They were decided in a very different media landscape, what I call media landscape 1.0, where you had big, powerful news organizations and that were primarily limited in time and space. Print newspapers disappeared the next day, largely. Broadcasters could only reach so far. We now have a very different media landscape marked by the incredible power of social media and the internet. And as my colleague Emily Baslin wrote in a very perceptive article in the New York Times Magazine earlier this month, it's not just the right that is critical of press freedom, of freedom of expression, it's also the left. They're also looking at this question of, and we've heard some of this today about disinformation and misinformation, has the First Amendment essentially grown old and no longer serves us? And I think that's an important question. Do we have the balance right today between free expression and other interests? But the courts are the place to do that recalibration. That's what the rule of law is about. Clarence Thomas 2 years ago wrote a concurrence in a case called McKee versus Cosby, where he said it's time to revisit Times versus Sullivan, that great 1964 decision that changed the course of libel law. And Justice Thomas found that, in his view, Times versus Sullivan had been wrongly decided. My colleagues and I criticized that concurrence. We asked lots of hard questions about it. We questioned its reasoning, but that speaks to the rule of law, to have those issues decided by courts, not in the streets and not through the misuse of litigation. And that's what I really want to focus on is what I've seen over the past 4 years in the realm of press freedom. Two disturbing trends, not about seeking recalibration of press freedom under the rule of law, but attempts to silence, to go outside the rule of law and change political discourse. The first of those is the weaponization of libel suits. In my time at the New York Times, which goes now back 18 years, we averaged about 2 libel suits a year, not many. Times versus Sullivan works and certainly seemed to work, but it discouraged libel suits by those who had a political agenda rather than wanting to protect their reputation. Over the past 18 months, however, we've had 10 libel suits brought by those known for their political agendas. A Fox News commentator, the publisher of the anti-immigration website VDare, Liberty University, Eddie Gallagher, the Navy SEAL and favorite of President Trump, a British academic with ties to Michael Flynn, 3 suits from the Covington Catholic students who were involved in the incident on the National Mall in Washington in January of 2019 with the Native American activists. And of course, the case in New York Supreme now, Donald J. Trump for president versus the New York Times. One of 3 suits that the campaign has brought against major news organizations, claiming that opinion pieces had somehow defamed the campaign. The cases are brought in the name of the corporate entity that is the campaign and not by the president, but there's little doubt what's really going on in those cases. All of these cases seem to, whatever their legal merits, all these cases seem to have purposes other than protection of reputation or even winning. We now see organizations who sue us use that lawsuit for fundraising purposes. We see them use them for publicity, and they're obviously designed, if they can, to inflict financial costs. None of this weaponization of libel suits is anything new. In fact, if you read Times versus Sullivan, 1964, that was precisely the issue that was behind the decision, the 9-0 unanimous decision by the Supreme Court to bring First Amendment protection to publishers in libel cases. There, it was white power brokers who were trying to silence the Northern press from talking about Jim Crow laws, talking about the heroic activities of civil rights protesters, of voting rights activists. And the Supreme Court said, enough is enough. We're not going to allow libel law to be misused to try to silence. And that remains a challenge now, or a new version of that challenge today. A news organization like the New York Times or CNN can take these suits and deal with them and defend them and ultimately, I think, prevail in them. But when you look at the financial hardships already facing many publishers, especially local news publishers, these kind of weaponized libel cases are in fact death blows, or at least blows that are going to significantly harm, and in most cases silence, organizations that don't have the money to withstand them. Is a serious problem that we need to look at. At the same time, I want to go to what I think is the second problem and the second attack on the press as well as the rule of law, and that's literal attacks, dealing with both the physical safety and the mental health of journalists who are attacked physically and attacked online. Every day I receive an email from a company that we have hired that does nothing more than look across the internet to see which of our reporters have been threatened. The attacks are vile. They are aimed almost always at women reporters, women journalists. They run the gamut from the usual hateful things to pointing out they know where the journalists' kids go to school. When I go to the New York Times building, I now have to pass through physical barricades outside to prevent an attack by a car bomb. There is an armed guard now in the lobby. We saw it with the bomb threats against CNN, which you'll remember from a year or so ago. But let me use 3 examples to try to give texture to this, because we all understand threats of violence are bad. We all understand that this has been happening to journalists too often. But I think that hearing the particular stories is also important. Earlier this year, Tucker Carlson denounced a Time story on his show on Fox. And in doing so, he specifically called out a freelance photographer by the name of Tristan Spinsky. Tristan had actually done nothing, hadn't even begun to work on the story. The story was an innocuous piece about how Tucker Carlson lived in a small town in Maine and how his presence had affected the townspeople there. But he was called out by name. And the important thing to know is that Tristan and his wife, who's a hospice nurse, live in rural Maine. They have gone back into the country to find their paradise, if you will. Within an hour after the broadcast, their phone began ringing and messages were left. One of those messages, according to the 911 call that was made by the family, is, "We know where you live." And within a few minutes, someone was on their property. That kind of chilling physical violence is not simply the abstract violence we see online. That is the for real kind of violence that would worry any of us wherever we are. Then there was the second incident I wanted to remind you of, which is when a congressional candidate by the name of Greg Gianforte body slammed a reporter from The Guardian during the campaign. Mr. Gianforte is now a congressman, and when President Trump tells the story of the body slam, he is always careful to add the further endorsement, "He's my guy," and you don't want to wrestle with him. Finally, I just want to point out the case of Robert Chain. Robert Chain was a California man who threatened employees at the Boston Globe. I'm happy to say that the U.S. Attorney's Office in Boston decided not to look the other way or not to treat these as just abstract threats, but dealt with them for what they were. As the AUSA said when Mr. Chain was prosecuted, when he was sentenced, Chain terrorized the employees of the Globe newspaper. As described by the victims, employees feared for their lives. Employees feared for their lives just because they were doing their jobs. In 14 calls to the Globe, Mr. Chain said, "You are the enemy of the people, and we are going to shoot you all. You are the enemy of the people. We will hunt you down and kill you and your dogs. We're going to shoot you in the head. We're going to shoot every one of you." One doesn't have to guess where he heard language like that. Look, are these kind of threats typical? No, but they create an environment of fear. They create an environment where people doing their jobs, doing their constitutionally protected jobs, must worry about their physical safety. And isn't that the real world opposite of the rule of law? Isn't the rule of law meant to make sure that we don't have to live with that kind of fear no matter where we are placed in society? There are no easy solutions to this, whether we're talking about the weaponization of libel suits or whether we're talking about threats, physical violence against our institutions that are devoted to creating and bringing to the American people transparency and accountability. But we do need courts that are going to recognize the need to be vigilant about the use of courts for political purposes and willing to stand up to that, recognize it, see it. We need to get support for an independent press from outside our own industry. It's one thing when those of us inside talk about it, when those outside in business, in Republican circles, conservative circles are willing to stand up for press freedom, that will have an incredible impact both on journalism safety and on the rule of law and on the vitality of a free press. There also has to be, I think, because there's no easy answers here, commitment to civic education. If we are going to honor the First Amendment, Anthony talked about this earlier, we have to tolerate a lot of speech we disagree with. And that requires us to have citizens who are able to think, to discern, to make judgments, to seek the truth. It's not an easy process. It's not going to happen overnight. That's going to require us to begin at a much earlier age to help children understand how to navigate a world of social media, a world where the choices are much harder and the truth much harder to find. When I was writing my book, right after I wrote my book, I received an email, and I could tell from what I could see when I looked at my inbox that it began, "Why did you write this book?" And one of the things that someone in my job knows is how to recognize an email that's going to be difficult to read. As you can imagine, people write to me with all kinds of claims and strange things. I often get emails from people who say things like, the CIA planted transponders in my brain and the New York Times won't write about it. That is 50% true. So I didn't read that email. It just seemed like wherever this writer was going, I didn't want to go. But the next morning I came in and I clicked on it, and it was a completely sane and wise email. It said, "Why did you write this book? You should be writing for young adults. That's where we're going to change America. That's where we're going to make a difference." And I thought the correspondent had it just right. We need to double down on our education system. We need to create democratic citizens at a much earlier age, that the things that we're doing aren't really going to matter much if we haven't really trained the next generation of citizens to have the tools they need to live in a modern democracy that's not going to look all that much like the one we have now, a democracy that's going to be dominated by digital communication and a constant battle for the truth. But it is one of those battles we can't walk away from. We need to win it. Thank you very much.
Thank you so much, David. So we have received a few questions for you. Starting with one about the legal standard for libel established by, I think, New York Times versus Sullivan, in terms of having to show malice on the part of the press in a libel suit. Nowadays, everything is politicized, you could say, or at least some people are saying. And obviously we hear our president talking about the press as being against him and everything they write is against him. Do you think that standard continues to be the right standard? Not that you could snap your fingers and change it, but do we need a higher standard, a more protective standard for the press to operate in this current climate? And maybe while we're on the topic of changes you would like to make, I'll bundle this with another question about press access. We saw over the course of this administration a lot of examples of the press access to particular reporters or outlets that he didn't like. And that has, of course, a terrible effect on the ability of those organizations to get news out and to help with transparency. Are there any rules that we could try to put into place on that issue to try to get fair access for all outlets?
Yeah, both good questions. We now move into the portion of the program where I surprise no one. I'm going to defend Times versus Sullivan. I do think that's the right standard. I think it is a standard that actually, when it is understood by juries and judges, works. And it is a standard that is easily, in most cases, understood by reporters to essentially require them to write what they believe to be the truth. The problem is that it is not a decision that is often, it's not a rule that's often decided at an early stage in litigation. So you still have the grind up of discovery and so forth to get to the actual malice question. And that's why anti-SLAPP statutes are so important. Anti-SLAPP statutes allow for early dismissal of libel suits that are not brought in good faith or with serious claims. The anti-SLAPP amendment to the New York State anti-SLAPP law is currently sitting on the governor's desk. It would extend the statute so it did protect journalists, and so it did protect publishers, not just citizen activists. That's the current state of the law. And it would be very unfortunate if Governor Cuomo didn't sign that, because it is, at this time, it is a really important bill to protect the press. As far as the press conferences, I write about this a little in my book, and since my book came out in 2019, Ted Boutros and the lawyers at Gibson Dunn have done an incredible job of litigating twice the right of reporters to attend press conferences at the White House, and won both of those cases. One's on appeal now. And that's a really good development, but it's also a sad development. There used to be democratic norms, and other speakers have talked about this. There didn't need to be a law that said members of the press, of the White House press corps, had a right to be at a press conference and ask tough questions. And sometimes those tough questions are going to be impolite. That's the nature of it. That's the nature of how we roll in this democracy. And what we're seeing is now it's going to require actual legal rules to make sure that people have that access. So that's a sad development, that what should be treated by norms, customs, habits of a democracy will now be more legalized. But in the end, getting that done is important.
We had a question about how you define press in this age of, bloggers, or whatever you want to call them, people who tweet constantly. There are all sorts of people who talk and have their views widely distributed who might not fall under a classic definition of press. So how does the current environment change that? And then we had a question about how, you talked about kind of educating the next generation about the importance of press freedoms. How do we try to teach people, and not just the next generation, but all of us, including older people, how to distinguish between real and fake news, right? That's one of the big issues of our day.
Yeah, so let me try to answer both of those fairly quickly. One is defining the press is an incredibly difficult assignment these days, as the questioner poses. The fortunate thing is the Supreme Court has repeatedly said that the rights of the press and the right of the public are the same, so it rarely is going to matter. Rarely are you going to see where being a member of the press actually has legal consequences. A matter of custom and habit, you may get different things. But it comes up, for instance, in terms of the right to protect sources, where there are state statutes that specifically say that this belongs to journalists and not to others. I think that the way out of that box, and there's no real easy way out of that box, is that we should look for acts of journalism. That when it comes up, for instance, when somebody wants to protect a confidential source, that what we should not ask is that person a journalist, but is she engaged in journalism in the particular story at issue? And that is it about informing the public, informing beyond the immediate people around her? As far as the next generation, I used to have this as a regular speaking point, and fortunately, one day I was on a panel with a librarian who actually had thought about what is it that we need to do. And the focus of what the librarians and others are doing is about evaluating sources, because that is the lesson that carries beyond any given story. How do you know? How do you recognize a good source? Second, when you have questions about that source, what other sources can you go to triangulate and double check? So it is really not about, well, there's obviously skills about discerning in any particular piece of content. Is that too good to be true? It's really about saying, okay, who's the source? What do we know about that source? Now let's go look at some trusted sources. Have they said something about the same topic? Let's check it.
Great. Thank you so much, David. We really appreciate your insights into this very important issue. And we hope that we'll have time to get back to you at the end with more questions. People did want to hear from you. So hopefully we'll see you again. Next up, we have Cecilia Wang. She is a Deputy Legal Director at the ACLU, and she directs the Center for Democracy there. She's the Director of ACLU Immigrants' Rights Project and is an expert in immigration and criminal law and the intersection between those two areas. Cecilia is also an experienced trial and appellate lawyer, and she speaks, writes, and teaches extensively in all of these areas. I think at this point, I'm just going to stipulate that all of these speakers are incredibly impressive and know their topics in. It's just been one after the other with these resumes. So Cecilia, we are excited to hear from you about our last topic of the day, which is immigration and asylum issues. Take it away.
Thanks so much, Jennifer, and thanks to my fellow panelists. I came in a bit late because I had a prior engagement. So I was asked to speak about the impact of the Trump administration on immigration law and policy in the US. And without question, although the president has made a mockery of the rule of law in myriad ways, he has almost certainly made his biggest impact in the area of immigration policy, a doctrinal area where the executive branch traditionally and historically has had such broad powers. So I'm going to start off by saying something that probably everybody already knows, and I don't say this lightly. The President of the United States has deliberately set about attempting to turn back the clock in the United States to a period of explicitly racist immigration policy meant to enforce the whiteness of the United States as a national community. And I say that, I don't say that lightly because I think there is a lot of talk these days about white supremacy and the ways that it is reflected in our daily lives in the communities we live in and work in. But I really want to unpack what I mean by that when it comes to the federal government during the Trump administration. The president, of course, began back as a candidate promising a complete shutdown on Muslim immigration to the United States, and that is a direct quote. He asserted that Mexican immigrants are criminals and rapists. And then as president, the first actions he took in office in his very first week after being inaugurated were to issue 3 executive orders that in broadly sweeping ways reversed the course of modest pro-immigrant policies of his predecessor, President Obama, and then engaged in sweeping changes that really tossed aside all of the trends in the modern executive branch. As president, Trump lamented during a meeting with members of Congress that temporary protected status permits immigration from shithole countries, famously referring to African and Caribbean countries, and asked why the United States does not attract more immigrants from, again, I quote, countries like Norway. And during the COVID-19 pandemic, Trump has deliberately referred to the virus as the Chinese plague, fomenting anti-Asian sentiment and attacks on Asian Americans. And finally, he's infamously given shouts out to Nazis, including the white supremacists who marched in Charlottesville and the Proud Boys most recently during his debate with Vice President Biden. Now, those frankly racist statements as reflections of animus toward racial minority groups and religious minority groups were translated by President Trump during his first week in office, as I said, into official US government policies that flouted the Constitution and blew up all kinds of norms for presidential comportment. He, as I said, issued the 3 executive orders on his 5th and 7th days in office, one engaging in sweeping anti-immigrant policies relating to border enforcement, one about interior immigration enforcement, and then the first of 3 executive orders instituting his promised Muslim ban. He has also instituted numerous policies, probably a dozen or more, eviscerating the US asylum system and longstanding policies and practices of the United States government when it comes to refugee resettlement, when it comes to the admission of non-citizens into the country. Those included, probably most notoriously, his official policy of separating families, taking even infants and toddlers away from their parents, even when those families had cleared the first hurdle to apply for asylum in the United States. He has instituted blanket detention of asylum seekers, again, a 180-degree reversal of prior US policy, which generally would release people seeking asylum who've cleared the initial hurdles to live in the United States while they defend their deportation cases and pursue asylum. His attorneys general, Barr and Sessions have issued AG opinions that reversed, again, longstanding US law. First, providing that no bond would be provided for arriving aliens who are placed in expedited removal proceedings, a summary form of removal that became part of the US law in 1996. Another one that purported to gut asylum standards that apply to most Central Americans from the three countries, Honduras, El Salvador, and Guatemala, that are the sending countries for so many asylum seekers that are coming to the United States at the US-Mexico border, and specifically targeting claims of persecution based on gender violence and gang violence. He's issued several proclamations or executive orders that could be labeled asylum bans. The first one only permitting people to raise asylum claims at official ports of entry. His forced return to Mexico policy, now in the Supreme Court, an ACLU case on his Orwellian, his policy with the Orwellian title of migration protection protocols, which sends immigrants who, again, have cleared the hurdle to file an asylum claim in the United States, forcing those immigrants to return to Mexico, particularly in areas where the United States State Department has issued travel warnings saying that those areas are as the equivalent of war zones in their dangerousness and the uncontrolled violence. He's issued an expanded rule for expedited removal, applying that proceeding, again, the summary proceeding, to people who are not just apprehended near the border, but anywhere in the United States. He has signed these safe third country deportation agreements with Guatemala and Honduras. And of course, most recently has issued, basically closed the border of the United States using COVID, or as he calls it, the Chinese virus, as an excuse. He slashed refugee resettlement to virtually zero, doing away with the US tradition of doing its fair share as a safe global first world power and providing a new start to people who need humanitarian protection and come to the United States to seek it. There's his border wall boondoggle, building his border wall, although Congress had refused him the funds to build it to the extent that he wanted. His two efforts to use the 2020 census to exclude and terrorize immigrants, and his ongoing refusal to protect people who received DACA relief, Dreamers, under the Obama administration's program. Now, I go through that recitation just to remind us all of the scope, to try to give you a sense of the full scope of the damage that the Trump administration has done to US immigration policy and law. It's not just a reversal of Obama administration policies, goes far beyond that in ways that I want to tease out just very briefly in the few minutes that I have left. These Trump administration policies have unquestionably destroyed countless lives and inflicted immeasurable damage on individuals and families in the United States and for those seeking to enter the United States. But the policies that he's enacted have also done long-lasting damage to the laws and norms that have traditionally constrained executive branch power in the immigration arena, and more broadly have affected in a negative way the legitimacy of all three branches of the US government, including most notably the Supreme Court. The The Trump administration, through its immigration policies, has effectively made a mockery of the notion that US government officials are subject to the rule of law, just as we individuals are. The second point I want to make is that Trump's departure from office, whenever that may be, will not magically result in restoring the rule of law in the ways that he's trampled on it. It is going to take significant work to undo this damage for three reasons that I think it's worth pointing out here. First is that although Trump's policies are extreme, uniquely extreme, even in the context of administrations prior to the Obama administration, the conditions and prerequisites for those policies, for his extremism, have been in place in US law for many years. You might argue for the entire history of the United States. But in particular, the immigration law passed by Congress and signed by Bill Clinton in 1996, the Illegal Immigration Reform and Immigrant Responsibility Act, instituted all kinds of measures that have flown in the face of due process ever since. We have mandatory detention, essentially pretrial detention, for immigrants who are in removal proceedings without any individualized hearing on flight risk and danger. Expedited removal, also enacted as part of the 96 Act. Limitations on Article III court review of those removal orders issued by the executive branch. We also have an important law of even older vintage, 8 U.S.C. 1182F, which is the provision from the 1952 Immigration Act, which gives the president broad powers to suspend the entry of non-citizens into the United States. This is the ground that the president has used for the Muslim ban and other actions he's taken to really target minority groups in his immigration policies. Even construed strictly, which the Supreme Court did not do, 1182F gives the president broad power to suspend the entry of non-citizens. There is a bill moving in Congress to partially fix this problem, but it is one that really has been given Trump a tool to enact his extreme policies. Other older doctrines and laws that apply are the plenary power doctrine, of course, and the entry fiction from the Mazzei case in 1953 and Landon versus Placencia in 1982, which essentially hold that although non-citizens in the United States have rights under the Due Process Clause of the Fifth Amendment, non-citizens who are apprehended or stopped at the border while seeking entry have only those rights that are afforded by Congress. And I want to point to some recent practice. Anyone who thinks that Joe Biden is going to be our savior on these issues probably has, I hope I'm wrong about this, but I think it's going to take a lot more work than simply getting a successor to Trump elected in order to fix these policies. Some of you may recall that in the summer of 2014, when the current surge of Central American people seeking asylum came to the United States-Mexico border, President Obama, Vice President Biden, and Secretary of Homeland Security Jay Johnson all stated, astonishingly for attorneys, that they would immediately detain and deport these families, mothers and children, coming to the United States and seeking asylum, and announced that none of them would qualify for asylum in the United States. They explicitly made these statements in order to deter other Central Americans from coming to the United States to seek asylum. Astonishing, and it is a sign of the ways in which immigration policy has been influenced by a frame of criminality, a frame of fraud, and all false frames. The second point that I wanted to call out is that the Supreme Court has largely failed to serve as a meaningful check on abusive political branch actions. There has, of course, been the recent use and ongoing use of the Shadow Docket to reverse lower court injunctions in immigration cases, including on the border wall and the forced return to Mexico policy. There's the Muslim ban, where, of course, the Chief Justice, I think in the most disturbing passage of the opinion, explicitly closed his eyes to clear evidence of the president's animus toward Islam and Muslims, as Justice Sotomayor pointed out in dissent. There was the DACA decision, which is, of course, a victory for immigrants and for so-called dreamers, immigrant youth who came as young children to the United States. There again, although the Chief Justice wrote the opinion for the court that essentially gave the Trump administration a mulligan, the court explicitly closed its eyes to clear evidence of the president's animus once again. Many of the plaintiffs in the multiple cases that were consolidated in the Regent's case at the Supreme Court had raised equal protection claims, pointing to evidence of the president's animus. Again, arriving at the United States Supreme Court on a motion to dismiss, or at the motion to dismiss stage, we saw an opinion that ignored the fact that the president had expressed racial animus against Latinos, and evidence that the DOJ had engaged in, I think, what could most generously be referred to as sharp practice in failing to even submit an administrative record in an APA case. We've seen in the last term also 2 decisions on immigration that really trampled on precedents of the court without any kind of sufficient reasoning to explain the departure from precedent and common law history. Thrasingham, again, a ACLU case where the court held that our client, Mr. Thrasingham, a Sri Lankan Tamil who had come to the United States and been apprehended in the United States, just inside the border, could not file a habeas corpus petition in order to challenge his removal order. Again, cases, and Hernandez versus Mesa, a case in which the court held in a Fourth Amendment case, again at the core of Bivens, that there would be no Bivens action for the family of a teenager who was shot and killed by US Border Patrol agents. I'll skip to my third point and then quickly wrap up. The third point I want to make is that, as I already alluded to, the frame that has become predominant in lawmaking and policy making on immigration in our country has been one of criminalization. It has fully infiltrated not only the halls of Congress, the executive branch, the federal courts, particularly the Supreme Court, but also United States public opinion. And I want to go back to the DACA case, Regents versus Trump, where we saw the case litigated in a way by many of the plaintiffs, but notably not by immigrant youth themselves, that reinforced this binary of innocent versus deserving immigrants. And that Trump's predecessors in Arizona and Alabama and Georgia, Vice President Pence when he was still governor of Indiana, all have pushed out so successfully this binary trope of bad immigrants and good immigrants. And the irony of that is that the government itself has eroded the rule of law, and particularly fundamental civil rights and civil liberties, in pursuit of immigration enforcement goals. So to restore the rule of law and the legitimacy of our US government institutions, we need to see the repeal of draconian laws enacted by Congress, the imposition of real checks on executive power against individual liberty, and a reset of the way that we Americans feel about immigrants. I'll end in 30 seconds just by telling a story about an ACLU case that I haven't mentioned yet and that has been lower profile than the other cases I have mentioned. In 2017, one of the things that the president did in the field of immigration was to suddenly go and reinstate old removal orders against national origin groups. He went after Somalis, he went after Iraqis, he went after numerous nationality-based groups where due to country conditions, people couldn't be removed. And so you had numbers of people who had old removal orders, but had in the meantime established themselves in the United States. One such person was our client, Sam Hamama, an Iraqi Christian. He was ordered deported more than 20 years ago for a firearm possession offense, but couldn't be removed at that point in time because Iraq was not issuing travel documents. In the meantime, Sam grew his own business with his wife, Narain, also an Iraqi immigrant. They raised their 4 kids, Brittany, Christopher, Lauren, and Lindsay in Michigan. And he was suddenly arrested in 2017 in the early morning hours at his home and thrown into immigration detention and put in reinstatement of removal proceedings. We filed a habeas corpus petition for Mr. Hamama, and I just want to tell you what the district judge in the Eastern District of Michigan wrote and end on this note. He wrote, "The Supreme Court is instructed, it must never be forgotten that the writ of habeas corpus is the precious safeguard of personal liberty, and there is no higher duty than to maintain it unimpaired. And under the law, the federal district courts are generally the first responders when rights guaranteed by the Constitution require protection. In fulfillment of that mission, this court concludes that it has jurisdiction in this case to preserve the fundamental right of habeas corpus and the duty to do so." The courts don't do it alone. At the end of the day, it's really up to ordinary Americans to lead the way. But as attorneys, we have a special obligation to keep defending our core constitutional principles, even when they're still aspirational, in order to make them a lived reality for all. Thank you, Jennifer.
Thank you so much, Cecilia. So we have had some questions come in for you. One question is in terms of the courts and what we've seen from the Supreme Court, and I fear we might actually know the answer to this, but I'm interested in your expert opinion. What do you think the addition of Amy Coney Barrett will mean for these issues at the highest court?
It can't mean anything good. I haven't gone through and tried to take a look at what she has said about immigration law in particular. But it's clear already through what we've seen from the court's shadow docket with stays issued against our victories in lower courts that we're already in a bad position when it comes to the court. There are many 5-4 losses that we've suffered already, including in cases recently that have construed the mandatory detention statute, 8 U.S.C. 1226C. So, you know, to be honest, I think one of the reasons that I've kind of ended with a peroration I did is because I do think we're looking at a long road ahead that's going to require political action as well as action and through litigation in the federal courts.
Can you talk a little bit about the fact that immigration judges are part of DOJ, and there have been reports of pressure put on them by the Trump administration to move things quickly, very conservative judges being appointed to those courts. What do you think about those issues, and how do you feel about the notion of immigration judges being part of DOJ, maybe being pulled out and be more independent?
Absolutely a good idea. I think, or I understand that Judge Sankov probably has spoken on this issue already during the panel. And I definitely support taking immigration courts and all of the Executive Office of Immigration Review out of the enforcement arm of the government. There are just too many ways in which ICE prosecutors have an edge in the courts, even before, in the immigration courts, even before the Trump administration started trying to throw the game even further.
Finally, do you think that what the Trump administration has done in this arena is so far beyond what the law permits that the participants in those policies, the child separation policies, the asylum policies, could be and should be held responsible criminally and or civilly?
it's hard to say. They certainly should be held responsible civilly. We have our ongoing litigation challenging the family separation policy. And as you all probably saw in the news in the last couple of days, journalists discovered through FOIA requests that were litigated by the federal government that there are hundreds of families that have been separated, and those children and parents can't be reunited. They're simply literally lost. I think people who've been involved in those policies need to certainly pay a political price, as well as make amends and pay redress to the victims of their policies. Whether there's criminal liability is not something I've looked at, though. But I do think it's important to hold government actors responsible. It's important to hold members of Congress responsible. And as I said, it's if we see a Biden administration, those are going to be key decisions we've made, whether to reverse those policies, how to reverse those policies, how to do better than the Obama administration did in 2014, when it saw the beginning of the surge, the so-called surge of Central American asylum seekers.
Great. Thank you so much, Cecilia. We actually have not yet heard from Judge Sankoff. We're going to hear from her next. And I hope that we will have time after she speaks for everyone to come back, and maybe we can talk about some of these issues a little bit more. But thank you so much for your insight and your expertise in this such a critical area. Thanks.
Thank you.
So, last but certainly not least, we have Judge Mimi Sankoff joining us. Judge Sankoff is a United States immigration judge. She has been so since 2006. She's also an adjunct professor of law at Fordham Law School. She writes and speaks extensively on immigration law issues and participates in many groups, including as the vice president of the National Association of Immigration Judges. She has brought us visual aids also. So we have something exciting to look at, and we are very excited to hear from you. I think people don't know as much about the immigration judges and the immigration law system as they do about Article 3 courts. So it'll be very interesting to hear from you, Judge. And whenever you're ready, you can take it away.
Thank you, Jennifer. And thank you, everybody, for your patience with the challenging and concerning information you've been hearing. I wanted to give you some visual aids because it's complicated. There's so much detail. And I want you to walk away with some takeaways of things you can do to try to educate people about the concerns in the immigration area. So let's go ahead and advance a slide. Once again, my name is Mimi Sankoff, and what's critical for you to know is that I'm here on behalf of the National Association of Immigration Judges. Advance the slide, please. So that disclaimer has never been more important than it is now. I am not here as a Department of Justice employee. I'm not speaking on behalf of the Department of Justice. I'm speaking on behalf of the Immigration Judges Union. And my views were formed after extensive consultation with the leadership and the membership of the judges. And so we represent all of the immigration judges around the country that are non-managerial. Slide, please. So one of the things that you may not know is, how many immigration judges are there? Well, right now there are about 500 non-managerial immigration judges that make up our membership. We have almost 70 immigration courts around the country. And if you've been paying any attention to the immigration issues and the immigration courts over the past number of years, it would not have escaped you to learn that we have an extensive backlog. When I was preparing these slides, we're at about 1.246 million case backlog. So when you do the numbers and figure out, how many judges can actually accomplish addressing those 1.2 million cases, it turns out to be about 2,500 2,500 cases per judge. And the judges themselves are essentially, in normal times, non-pandemic times, are on the bench every day, all day, doing about 2 to 3 to 4 trials a day, and sometimes having what we would call our intake hearings, our master calendar hearings, of up to sometimes 100 master calendar cases a day. So the takeaway here is that you have high speed, high volume. Advance the slide, please. With that high speed and high volume, you know, how do the immigration judges successfully complete their responsibilities? Well, increasingly, they've been required to do more with less, and that is despite record appropriations. We share law clerks, even though, you know, there has been record numbers of appropriations for the immigration courts. We have seen that the majority of the funds, yes, has been used to hire new immigration judges, but also to fully develop this managerial rank of managerial judges who do not preside over cases, but instead manage and oversee the decisions of the immigration judges. And that's what's concerning, because it's created a layer of bureaucratic oversight. And what we've seen is an adoption of what appears to be a misguided mid-level management philosophy. And that has just exacerbated this backlog, which just keeps growing. So despite the record appropriations by Congress and the vast hiring of new immigration judges, we see incredibly more and more mid-level management prioritized at the exclusion of staff. At the New York Immigration Court, where I preside, we are staffed at less than 30% of the necessary staffing for those immigration judges that are presiding there. Please advance the slide. Now, why can't the immigration judges themselves just fix this problem on their own? You know, they sound like judges. You'd think that they have the authority to do so. But as you just heard Cecilia Wang mentioned a few minutes ago, it's because the immigration courts suffer from the fact that they are located within the Department of Justice, which is the, you know, highest level prosecuting entity in the United States. Attorney General not only control and of the which are led to a number of groups to has called for a real interest in the part of the non-governmental organization community, the American Bar Association, and a range of organizations to call for the creation of a separate court. It's really troubling when you see at the immigration court, the newest leadership is really the former prosecutorial wing of the Department of Homeland Security, now leading the immigration courts. And that individual, while a very knowledgeable individual, has no judicial experience and is yet selected as the leader of the immigration judge corps. Please advance the slide. Now, when you have a court housed within the Department of Justice, and it really has created an opportunity for politicization in the way in which cases are assigned, the way in which cases are resolved, and the way in which cases can be either placed on a docket or removed from a docket. And I'm going to explain that a little bit more in this session that we'll be discussing in a few moments. But so far, Congress has failed to rectify this situation, even though the Immigration Judges Union and many groups around the country have been calling for the creation of a new system that would ensure a truly independent immigration court. Our judicial system as it currently exists is really vulnerable to the extreme policies of an attorney general. And as of August of 2020, a number of US senators have called for a General Accounting Office investigation into politicization and mismanagement of the immigration courts, specifically during the COVID crisis. Advance the slide, please. We've also seen attacks on the rule of law in the form of politicized hiring accusations. In March of 2019, the EOIR director is viewed as having circumvented the normal hiring processes and gutting the normal procedural safeguards that you would have seen for hiring and staffing of leadership in terms of the immigration court and the Board of Immigration Appeals. But we've seen accusations of by a number of different groups of politicized hiring at the Board of Immigration Appeals and in other parts of the immigration court. We saw in August of 2019 that the EOIR promoted to the Board of Immigration Appeals specifically a group of immigration judges that had previously been criticized for very high rates of asylum denials, and some of which had been targeted with numerous complaints. We've also seen more recently, just in April of this year, that the DOJ and EOIR issued a new interim rule during the global public health crisis, immediately expanding the BIA from 21 to 23 judges, which is also of concern. You know, when you're in a situation like this, you've got judges who are trying to preside over extremely heavy dockets, meet their rule of law requirements, meet their constitutional due process mandates so that each case is given the due process and time that it deserves. But they're obviously subject to constraints given the volume of the cases that they are asked to preside over, given the fact that they, in this particular instance, have had the power to control their docket removed. They've really been struggling with the fact that they don't have the power to prioritize cases even. Pursuant to a recent case from a couple of years ago that was issued during this administration, matter of Castro Tum, it was decided by the Attorney General. The result has been that cases cannot be put on essentially a shelf and postponed. There's no prioritization because judges cannot temporarily administratively close a matter. And as a result, every case has become a priority. And when every case is a priority, no case is a priority. And with the over 2,000 cases that the immigration judges are each required to continually monitor, it's been very difficult for them to provide the justice that is expected of those that are appearing before those judges. We've also seen with this administration a lack of transparency. There's an organization at Syracuse University that issues and keeps very close tabs on all of the activities at the immigration court in terms of case completions, case assignments, and such. And this is called the track report. But the track report has been stating that there has been a lack of transparency and actually a lack of accuracy. Now, for the first time in the many years that they have been tracking information about the immigration court. So we're really concerned about the fact that that the information that's being provided to the public is faulty, as is argued by Syracuse University in their track report. You also heard Ms. Wang talk a few minutes ago about the MPP docket, Migration Protection Protocol. And this is the docket where there are many cases where individuals have been asked to and required to wait out the time before their case can be heard in Mexico. And this is something unheard of. We've never seen this before. And it's presented real challenges, as you can imagine, for the immigration judges to try to preside over cases, doing so during a pandemic from afar and with respondents who are not even in the United States and have difficulty accessing documents and then appearing before them for their court hearings. We're aware that in 2020, the Civil Liberties Union lawsuit was brought arguing that there are egregious due process concerns that have been alleged because of this new type of docket. And we're watching that, of course, very closely. But we're concerned as immigration judges, when we're required to notify respondents of their hearing dates. We don't even have addresses necessarily to send those letters to, advising them of their new hearings. Please advance the slide. We're also concerned about the fact that the Department of Justice has been implementing a series of regulations with extremely short public comment periods. The regulations that have been implemented are very broad, very unusual, and extensive. And they've been implemented without giving, oftentimes, a significant period of time for public comment. This is of concern. The vetting of those regulations is usually benefits enormously from the input that the decision makers receive from the general public when they have an opportunity to closely examine them. Another area of concern is the fact that the Attorney General in this administration has issued many decisions that essentially have create changes in policy. And this has been a heavy use, unusually heavy use of this procedure of the Attorney General certifying decisions to him or herself, and then issuing new decisions that have such far-reaching impact on policy. They've impacted the extent to which, as I indicated, immigration judges can actually close cases and prioritize so that they can focus on specific matters pending before them in a logical format. They've also been accused, this process has been accused of having reduced protections for private individuals who are the victims of private actors in their home countries, and gang membership because of a specifically narrow reading of the asylum law. These are the types of accusations that have been lodged about concerns regarding the heavy use of the Attorney General in certifying cases to him and herself, and then issuing those changes in policy. Please advance the slide. Another area of particular concern, which is endemic and really reaches every aspect of an immigration judge's role on the bench, and that is the imposition of a new policy of numerical quotas that measure immigration judge performance. Now, immigration judges for years have been subject to performance appraisals and performance reviews, but these new measures and mandate quotas, numerical quotas, and essentially have created a system where immigration judges feel that they are having to choose between finishing certain dockets and expediting specific cases to the and in doing so, potentially compromising the integrity of the court. This type of pressure undermines due process, and it has created an accusation that the system is now more unfair and inefficient and unethical. So these are all areas of particular concern, and we've been very active as a union in trying to fight against these particular measures. Please advance the slide. A lot of the concerns that I've been raising have been exacerbated during the pandemic. Surprisingly, it took a long time for the leadership of the EOIR to even recognize that there was a pandemic going on. We had to engage experts to analyze the safety concerns for all of the stakeholders and the immigration judges if they were to continue to participate in hearings, and go before a press corps to highlight for the agency how important it was to close down the hearings for a temporary period so as to ensure a safe environment. While no one takes lightly the notion of closing down hearings and creating a pause in any immigration court setting, it's mandatory and important at a time such as this to ensure the safety of those that are presiding and those that are required to participate, to ensure that the hearings are handled in a manner that is safe for all those involved. So while we recognize that certain cases have to be heard, such as bond hearings, there are workarounds for that, such as doing those bond hearings via telephone. And in many instances, that was not a solution that was being put in place for quite some time. Please advance the slide. One of the things that the Immigration Judges Union has been advocating for months is use of remote hearing technology, so that not only the judges, but also the participants can participate in the hearings remotely, doing so safely during the pandemic in specific cases where it's appropriate. One of the things that we've seen, because immigration judges were not able to hear the cases in an expedited manner because we haven't had access to that remote technology, there have been lawsuits filed because there are respondents who've been in detention and they have caught COVID while they're in detention. People have died, guards have been caught COVID and died, respondents have become ill and died. We've had judges get COVID. Fortunately, none of the immigration judges have yet died, but there have been many respondents' attorneys who have been trying to meet with their clients, and they've unfortunately, perished during this COVID crisis. And yet, in some instances, those immigration court proceedings have continued to go forward in detained settings in the middle of Manhattan, which is inexplicable to us why certain types of technology weren't used to try to provide a safe environment for all those involved, so as to avoid the risks and ensure that the cases could continue to go forward in a safe manner. Please advance the slide. One of the most recent and troubling outbreaks that we've heard about is in our immigration court that's located within the Adelanto, California facility. They've had one of the largest outbreaks of COVID-19. And as of just a few weeks ago, with a class action lawsuit pending, up to 58 detainees and 8 staff members had already tested positive for COVID-19 at that facility, and over 300 detainees were awaiting test results. 9 detainees had been hospitalized, and at that time, 23% had COVID. So this is extremely troubling, unacceptable, and cannot go forward in this manner. Fortunately, you have court leadership that's been addressing it. Please advance the slide. The detained immigration courts, as I mentioned, have continued to go forward, even though the physical courthouses have been unsafe. We have been calling for emergency court closures across the country repeatedly, and the use of technology in the meantime to provide a safe environment. The agency has been extremely slow to implement those types of protections. Please advance the slide. The overall lack of transparency is, as you've been hearing, is really very troubling. Because without transparency, you just don't have that accountability. This might be one of the few times that I'm going to be able to speak, even though for many years I've been able to speak not only as an immigration judge, I'm no longer oftentimes ever eligible to speak in my capacity as an immigration judge, either in my personal capacity or my official capacity. And we're very fortunate that the Columbia University's Knight Institute has brought a lawsuit representing the immigration judges, advancing a freedom of speech case, saying that our rights to free speech have been infringed for the agencies failing to permit us to even speak in our personal capacity. I can only speak in my union capacity, talking about working conditions of immigration judges in the manner that I am doing so here. It also is troubling because during the pandemic, journalists, for example, have had reduced access to the immigration courts. And that is a troubling instance, because we certainly need their oversight, their eyes on what's going on in the immigration court to ensure transparency and accountability. And finally, I would note that the Immigration Judges Union has been subject to incredible attack. While we've been in existence for decades, this administration has taken steps to decertify the union, and we're very concerned that will eventually succeed. And if that happens, then you will not have an immigration judge being able to speak even in her capacity as a leader, an official with the NAIJ, National Association of Immigration Judges. So with as much worry as we have about health and safety, fortunately, we do have some investigation going on by the Office of Inspector General, the General Accounting Office about safety concerns during the pandemic. And we don't yet know what the outcome is going to be of those investigations. But fortunately, those are going forward because right now, as the immigration courts are steadily reopening and non-detained courts across the country are actually bringing judges, staff, and the public back into the courthouse, the courts really are ill-prepared to protect individuals against the spread of the coronavirus unless a number of measures are taken to ensure safety. Please advance the slide. We've seen, as I indicated, parties suffering from exposure to coronavirus and then having to go into quarantine. Many of the immigration courts that open then end up having to be closed down repeatedly. And unfortunately, this has had an incredibly negative impact on the ability of those judges in those environments to ensure that the parties appearing before them can be assured of a safe environment. Please advance the slide. As I've indicated, we have been urging that the EOIR adopt remote hearings in the telework setting. And as soon as that comes into play, that will be good news for all those involved. Please advance the slide. What can you do? We need an Article 1 immigration court. And at this point, fortunately, we have a lot of support for that, not only by the American Bar Association, the Federal Bar Association, but this particular group has just come out with a report just today, this morning, supporting once again a call for an independent immigration court. So I will leave it there and thank you so much for your patience, your time, and your interest and further education of the community regarding the benefits of an independent immigration court.
Thank you so much, Judge Sankoff. We just have a few minutes, but let me give you a couple of questions that we received from some of our audience members. In terms of the power of immigration judges, most of us are used to Article 3 judges where, the judge kind of rules the roost. And if they want to appoint someone a lawyer, they do it. If they want to, whatever they can do to control things within their own four walls of their courtroom. I take it that immigration judges don't have that kind of power, because when we've seen in the press some reports of, there's a 2-year-old in front of the court, and that 2-year-old doesn't even have a lawyer, and those are problems that you would think a judge might just be able to solve by making an order on the spot. Is that right or wrong? What powers do immigration judges have to do that sort of thing? And if they don't have that sort of power, is that one of the reasons that you propose an independent court as opposed to a DOJ court?
Jennifer, the immigration judges themselves don't even have the power to order their own pencils. We don't have the authority to order more security in the courtrooms. We don't have the authority to open up our courts and close our courts. We don't have the authority to even modify really which cases are going to remain on the active dockets and which cases appropriately should be put to the side and other cases prioritized. They don't have that authority, and that's exactly why we need an Article 1 immigration court.
And finally, we got one question about the tension between, well, I guess it's an issue of managing judges, a tension between trying to get cases resolved quickly and efficiently with, of course, wanting judges to make high quality decisions. How does that tension play out in your view? Are things so rushed and are you so overloaded that the decisions are inevitably suffering? Is that one of the reasons that you're calling for additional judicial resources?
Certainly the process suffers and the access to due process suffers. When you don't have immigration judges properly resourced with the teams that they need around them. You heard, one of our speakers earlier, Miss Austin Hillary, talk with Human Rights Watch, talk about the reports that they create. Well, as an immigration judge, we read those reports. They get presented to us at our immigration court cases. They're not 2 and 3 paragraphs. They're 30 and 40 pages. If we can't read those reports and we're not given time to do that, justice suffers, because we need to know what's happening around the world. And with these very extremely heavy dockets, we're not being given that time.
Well, thank you so much, Judge, for joining us today and for sharing your important perspective. I do think that members of the City Bar and other members of our audience didn't know just appreciate your input today. I see that Stephen Cass has reappeared on my screen. I think that might be my cue to throw it back to him. I had hoped for some discussion as a group with everyone, but he's shaking his head no. He's putting up his hands no. So I would ask all of our audience members to join me in thanking our phenomenal panel of experts today who were so terrific in helping us understand some of the challenges of this administration as they relate to individual and societal rights. And I will toss it back to Stephen for our last goodbye.
Well, let me just say thank you, not only to all of our speakers, but to you, Jennifer, for a superb job as moderator, and to all of our audience members who stayed with us and who asked such incisive and important questions. Our next and final session of the Rule of Law Forum will be at 1 o'clock on Wednesday, November 18, after Election Day, and will focus on what both lawyers and non-lawyers can do individually and collectively to rebuild and, where necessary, reform the rule of law in the United States, including rebuilding a broad consensus supporting an equitable legal system, as each of our speakers have really so eloquently urged. In the meantime, we would urge you all to do the one thing that we can do on November 3, exercise your right to vote and encourage others to do so. Remembering, in the words of Justice Brandeis, that in a democracy, the highest office in the land is that of a private citizen. So thank you all very, very much. And thank you, Jennifer, and all of our speakers. And we will see you on November 18.